I need to turn. So
At the first meeting last September, I also stated, can we be successful? There was and is a lot of skepticism out there that we will fail, that this process is designed to fail. When I was asked to serve as co-chair, I agreed partly because I truly believe this is a historic moment in Colorado. Tens of thousands of Coloradans are now engaged in and directly affected by oil and gas development. We need to get to yes on addressing those top issues, and we have the opportunity to get to yes on all 10 of the priorities set out in the executive order. So with that, I hope we can get some hard work done today. Thank you very much.
Okay, we just have a few business items. We received no changes to the meeting minutes from the last meeting, so would like to suggest that we formally adopt those. If there are no objections or suggested changes.
Motion to approve.
Do we have a second?
Second.
All those in favor of adopting the minutes as written?
Aye.
Any opposed? Motion carries. Thank you.
Thank you. We also just want to quickly review the antitrust statement for the task force. Again, we have competitors in the room and want to make sure that nothing that the task force is undertaking violates any antitrust rules and regulations, and just want to make sure everybody is in accordance with this. If at any time there is any worry that we are venturing into that territory, if you let the co-chairs or the facilitator know, we'll cease discussion. Any questions about the antitrust statement? Everybody should be familiar with it at this point. Okay. With that, I'm going to hand it over to Christine to review our agenda and the process that we're going to use for our final discussions today.
Thank you, Sarah. Just to walk through the agenda, obviously the bulk of our time today is focused on discussion, so we'll be spending the morning walking through each of the proposals one last time, starting with those that have undergone the most revision and or are linked to others in their substantive area listing. So, and just as a note to that, obviously Bernie's number 17 is up first, and Bernie has been stuck in traffic, is probably 5 minutes away. So I think we'll work to get his timing. Once we have that, that discussion is going to be pretty open-ended. We do again have all morning. We think that'll be enough time. So it's a time for clarifying questions, for any comments you would like to make, and it is also an opportunity to offer amendments to be considered by the author. Only the author may accept an amendment to their proposal, so that discretion will be left in their hands. Once we're through all of the proposals, we will take a break. That is an opportunity for those authors who would like to amend or in any way revise their proposals to have the time to do so. The goal today is all proposals are final documents by the time our discussion is finished. We'll come back from that break where those folks who have been working on their proposals can walk through their changes so that we know again what those final proposals look like. We're then going to allow some caucus time for folks to consider whether or not it is appropriate to entertain voting today. And the ground rules for voting will be that it has to be done with unanimous support of this group. So everyone must feel comfortable with going forward with a vote. And then we'll work from there on doing votes that will be recorded by individuals if that is the next step. I will note that we have been working hard with all of you to get your timing on the next 3 days to see if there's a time we can get all 21 of you on the phone to do a phone vote, which would again be a public vote streamed on the internet. And right now we don't have a time in the next 3 days that we can get you all on the phone. So just know that that is a work in progress, and should we not decide not to vote today, we're going to have to frankly spend some time this afternoon trying to find that and how we can get it scheduled appropriately. So just to let you know, that's in the offing if we need to have that discussion.
And we'll go around and do introductions so people know who's at the table today who are listening in. We do have a number of alternates sitting at the table. Again, if we do get to voting, the alternates will not be voting on behalf of their members. If we do vote today, the ground rules that originally were established by the co-chairs of allowing 48 hours for those not in attendance to register their vote will apply. And we do believe Randy Cleveland, who's one of the 3 people who's missing today, will be able to be in attendance by phone. So that will just apply to Peter D. and Scott Woodall at this point. So any questions? Well, actually, should we go around and do introductions first? Okay, and then we'll see if there are any questions about the process. Kent, do you want to start?
My name is Kent Pepler. I'm president of Rocky Mountain Farmers Union.
Hi, I'm Lisa Wen with XTO Energy. Randy Cleveland, as Sarah mentioned, sends his regrets as he's iced in Fort Worth. Glad to be here today.
Steve Moreno, Well County Commissioner.
Dan Kelly, Noble Energy.
Becky Corliss, DU, I guess, for simple purposes.
I'm Matt Sura. I'm an oil and gas attorney working with local governments and landowners and communities.
Good morning, I'm Brad Hawley with Anadarko.
Will Tour with the Southwest Energy Efficiency Project.
Jim Fitzgerald, I'm a farmer from Bayfield, Colorado.
Good morning again. I'm Perry Pierce with ConocoPhillips, and I am, as was mentioned, the temporary interim stand-in co-chair. And with that number of modifiers, I think you have a sense. But anyway, I'm Perry Pierce with ConocoPhillips.
Sarah Alexander with the Keystone Center.
Christine Scanlon with the Keystone Center.
Gwen Lackle, La Plata County Commissioner.
Russ George, College Administrator in Western Colorado.
Sarah Barwinski, Welldare and Water, an impacted homeowner.
Pat Quinn, former mayor of Broomfield, Colorado.
John Golden Dubois, Western Resource Advocates.
Good morning, I'm Elber Wedgeworth. I'm the Chief Government Officer at Denver Health.
Jeff Robbins.
Bruce Rao, Colorado Association of Home Builders.
Ken Wanstall and Bill Barrett Corporation sitting in for Scott Woodall. And if we do get a defined time to vote this afternoon, I may be able to arrange for Scott to either be here or call in as well.
With that, any questions?
Before we begin, if I may jump back into this, I want the task force members to really think about the sort of structure that Christine was describing to us. There's been some question about whether or not we will vote today and under what conditions. And I want to try to summarize my understanding, and Christine may indicate that I don't understand, but I might not be the only one. We are expected to vote on all of the recommendations that are under consideration in the same block of time. Whether that block of time is today or Wednesday, Thursday, Friday, we do not know. But all of the recommendations would be voted on in the same block of time. The decision of whether or not all of the recommendations can be voted on today will be made later after we have walked through all of the recommendations. And as I understand it, and this might be important, am I correct, Christine, that if any task force member objects to voting on even one recommendation today, that means that the votes will not be taken today? Is that the ground rule that I understand?
That's correct.
Okay, thank you. I just want us all to understand, because later in the day, we're going to have to make some decisions. So thank you for allowing me to do that.
Yes. Any further questions or comments on the process that we have before us today? Okay, that will be how we proceed with our work. Bernie, of course, is not here, and he was supposed to be first up. We can move, should we go to the next block or the next issue? I know he's seconds away. We can move on to, hold on, we're going to see what makes the most sense for you all.
Hey, Christine.
He's in the room.
Goodness, I have never waited with such anticipation to see Bernie. Okay, let's wait for Bernie.
Yeah.
I hope. We will let you settle down for a minute, Bernie, and get coffee or water. Okay. We just went through, just to catch you up, we went through the process today, which will be to discuss all of the recommendations, starting with those that have undergone the most revision and are linked to others that are on the table. Amendments can be offered, only accepted by the author. At the end of that discussion, those proposals that the author would like to revise or amend will be given some time to do so we can finalize them. Come back and go through those final changes to any last proposals. And then we will at that point need to make a decision on if voting is an expectation today. But we are starting with yours because it met all of the above criteria as to go first, and it would be number 17.
Thank you. And first of all, I apologize. I thought that 2.5 hours was plenty of time to take my wife to DIA. And I-70 just didn't cooperate very well. 17, I think everyone here has had a chance to read it probably more times than they would have liked. But 17 took the original 13 and the original 17 and combined them, added the mediation process that Justice Corliss had worked on, and added clarification of the authority of the director of the COGCC when confronted with applications for permissions to drill that do not adequately balance the industry's right to access their minerals with health, safety, and welfare. Obviously, this has gone through many drafts, and I would like to thank all of the folks that have assisted me, pointed out the treacherous nature of some of this language, and I appreciate all the recommendations that went into this. And I think I'll stop there, but I would try to answer any questions that anyone might have.
And this should be a dialogue, but if you'd use your cards to make sure that everyone who wants to speak has an opportunity. Matt Sura.
Yes, thank you, and thanks for all your hard work on this, Bernie. I was curious what the relationship between 17 and 13B is. They seem very similar, and I'm just wondering if 17 moves forward, will 13B be withdrawn?
Thank you. And Brad Hawley is my co-submitter on 13B. It is, I believe, our hope that if 17 garners wide support, we would withdraw 13B.
Yes, Bruce Rao.
Sorry, Ken.
I knew who you were.
So Bernie, I think I'm a strong supporter of this proposal in almost all facets.
Thank you.
I think the one area that it still seems lacking is that in the process of establishing a dispute resolution process, the surface owner is excluded or not included in that process. And I think to the extent that the dispute is over surface location, then I think it's critical that the surface owner is included. To the extent that this dispute is over some other issue, I don't think that it's important necessarily. But I think when we're dealing with surface locations, and including in your paragraph 3, again, I think you're talking about alternate surface locations there, and I think it'd be inappropriate to exclude surface owners from those discussions.
Thank you, Bruce. I very much understand that concern. It was mentioned to me by a couple of other folks. Unfortunately, the concern came to me too late in the process for me to deal with it. I would hope that when the COGCC goes forward with this, that they look at that issue and draft rules accordingly.
Follow on, Bruce?
I just follow up, and if there are any task force members that have a particular disagreement about that or anything to add to that, I'd like their feedback, because if we're moving forward without an amendment to the proposal, I'd like to know if there's an issue.
Bruce, and let me add, I tried to think through that, and when you're talking about potentially alternate locations, determining who is the affected surface owner becomes a very difficult and challenging issue. And again, I didn't start thinking about that issue until too late in this process, and didn't devote the quality time to it that it deserves, but I would hope the COGCC does.
I had Perry Pierce followed by Becky Corliss and then Russ George.
Thank you. I want to step back and have us think about process again. We have a situation in which 13B may be withdrawn, and I particularly, I think, want to ask Keystone how they feel, and then perhaps others want to comment. I don't know what we ought to do in this substantive discussion process in that situation. I don't know. Right now, I don't know what to do with 13B.
I think we will still go to 13B as next on our list. I think it's fine for the authors, Brad Hawley and Bernie Busher, to talk about intent if 17 goes forward, and if there's anything substantive, anything else substantive they'd like to mention, they can, or someone can ask a question. But this is we have several linked proposals, so it is an opportunity for folks to say whether or not they would withdraw a proposal should another go forward, for example, or if they're very, very similar, that they prefer one over the other, that kind of thing. Brad, did you have any follow-on to that?
I guess my thoughts on that is that at the last meeting, we committed to combine 13 and 17, and we did that initially with 13B, and so it sits out there. Bernie's done a lot of wonderful work since that time on 17, I think, incorporating a lot of input. So we wanted to hear the discussion today and see how that goes.
Yep.
See if there's support, strong support for 17 or not, and see what the group thinks about that. But that's kind of the history on why they're both still out there.
Yes. This is also why voting through all of these is important, so folks understand that sequence. Becky Corliss?
So, Bruce, I had the same concerns that you voice. I too am a supporter of 17, and I had suggested some alternative language to acknowledge surface owner rights in this process. I do think that in paragraph 2 on page 2 of the new 17, if you look at the second sentence from the bottom of the text, it does say recognizing the requests and concerns of the surface owner on whom such facilities may be located. I had asked that the word rights be inserted in that sentence as well, but I think as a practical matter, it's going to be hard to recognize the requests and concerns of the surface owner unless they figure out who the surface owner is and talk to the surface owner. So it implicitly requires notice and inclusion. I'm worried that it doesn't explicitly require notice and inclusion, but I do think that Bernie has tried to build into the language an acknowledgement that the surface owner rights have to be taken into account in this process. So I guess I speak to say, I both share your concerns and I would prefer different language, but as a practical matter, I'm not willing to vote against 17 absent that language.
Very good. Russ George.
Thank you. Bruce had sent out to all of us, I think sometime last week, timely certainly, a document that indicated there were a number of these proposals that all lacked the reference to surface owner rights that he's advocating now. And it causes me to want to say at some point we have to have that larger conversation about surface owner rights, because it isn't just 17, it's half a dozen others. And I think the effect is the same if we follow your recommendation. My problem is I don't know what the effect is. There is a distinct body of law today on the issue of protection of surface rights. That body of law probably resolves those issues or sets processes to resolve those issues that may or may not be included in any local government or state process. And I think we ought to try to resolve here first, because it'll matter later in the day. If we intend to insert language here that gives the surface owner, and I guess it can be multiple surface owners, because the conversation may include, do we want it here or there or there? Local governments no doubt will be suggesting that. Where do we then give the notice to what surface owners? It seems to me it expands differently depending on where you are in the process. And I'd like to have more conversation about it. You've asked for the same issue in a couple places where we're adding alternate dispute resolution, but it isn't clear just by inserting and include the surface owner what that means. Does that put the surface owner on equal standing with the operator, with the state, or with local government? So if you've got some concepts that you can describe to us that'll help answer my point, it would be helpful.
Bruce Rao, would you like to respond?
Yeah, thank you. Respecting Rebecca Corliss's comments, I think I agree in terms of the general idea that this includes concepts around surface owners. I think the particular spot where it doesn't is in the alternate dispute resolution. And I think to the extent that the alternate dispute resolution is relating to a surface location or alternate surface locations, I think the surface owner has to be a party to that dispute resolution. That would be my recommendation.
John Golden Dubois, followed by Will Tour.
Bernie, I wanted to let you know first that I support your number 17 and plan on voting for it. I think you've done a good job, and I want to commend you in trying to bring together a variety of interests that are not always similar in nature. I do want to say that I don't think the proposal goes far enough to address some of these issues that have already been identified, including those rights of surface owners, adjacent surface owners. But more importantly, I don't believe it gives people in communities all of the tools that they need to address many of the issues we've discussed in whole. So when we look at issues of siting, when we look at issues of proximity and scale and some of the health implications, I'm not sure we get fully there, but I do think this represents modest steps in the right direction, and I wanted to let you know that. Thank you.
Thank you. Will Tour, followed by Ken Wallstolin and Dan Kelly.
Thanks. I have several questions to make sure I completely understand the proposal. One is on the first page, in the fourth paragraph under the heading third, the proposal refers to giving additional authority to the director of the COGCC to address both citing and I think conditions of approval in order to limit the impacts of multi-well sites. And as written, that paragraph I would interpret as giving the director that ability independent of whether a community is going through the process that is laid out below. So I guess that's a question, is are you intending to give the COGCC additional ability to address siting and mitigation in order to mitigate the impacts of large facilities on surrounding residents in all cases, or only if a community chooses to go through this process?
Well, if I understand your question correctly, I believe that's in all cases.
Great. Second question is at the top of the next page, number 1 refers to an expedited process if a local government has in place a plan that specifies locations for oil and gas operations. And I'm trying to think through what that means in the context of some of the testimony that we've gotten from residents, for example, in Greeley or some locations in Weld County, where we had residents who clearly had major concerns about locations where there was not necessarily a major local government concern, but there was a major concern by nearby residents. And when I look at the COGCC process, about the only place that I really see an ability to expedite it would be by reducing the sort of public input into that process. So I wonder if you could speak a little bit to what is meant by expediting an application if the local government has the location in a plan, and how would community concerns that are not necessarily represented by a local government be addressed in that case?
Will, can I get back to you on that? There's been some good discussion about expedited process, and I think Matt Sura has been very articulate in saying that no process should limit the right of affected individuals to have their voices heard. And I don't intend that happens here, but I need to look at the language a little bit more to answer that question as well as I'd like to.
And I have 2 more questions. One is on the timelines that are set out in number 7, that the local government planning process and the mediation process together may not take more than 90 days. And I guess as a local government guy who's been involved in a lot of land use processes that have, in many cases, I think far less impact on a neighborhood than putting a multi-well production site would, I cannot imagine a meaningful local planning process that could take place within that time frame. And I'm wondering how that 90 days was arrived at.
Page 3. Well, I have to say that I think partly came from Justice Corliss's original language, but there was also an intent that this process not be used by either party as a way just to simply delay getting a decision. And 90 days seemed to be reasonable. I didn't get any feedback from that, but it seemed reasonable.
Well, I guess a commentary again from having been involved in many local government land use processes. If there's going to be public involvement in the process, I don't believe it is possible to have a land use process in which there's an ability for the public to get educated, adequate notice for public meetings, and a decision to be made on something of this magnitude, and then still time to go through this mediation process in a 90-day period. I have a very hard time.
I understand that. I anticipate, though, that before the mediation process begins, there would have been much discussion and much publicity about the issue. So it wouldn't, be ab initio at that point. It would be an issue that in a community had been at least moderately well publicized, I would imagine.
Okay, I was interpreting this as 90 days from the start of the process, not 90 days from the start of the mediation. So maybe just something to think about. Then one final question.
Maybe something the COGCC would look at.
One final question. On the bottom of page 1, it states that nothing in the recommendation would be intended to alter any existing local land use authority. So just to make sure I understand, so if a local government chooses to go through this process, and if they ultimately disagree with the decision made by COGCC, if that local government requires a local permitting process, they would still have that local permitting process. They would still make a decision based upon their own criteria. And if that decision is inconsistent with the COGCC decision, the operator would have the ability to challenge that in court.
Will the language that you're looking at probably was parsed and reviewed more than any other language. And there are some members of the task force that feel strongly that communities have many of the authorities that we're talking about and that they would win in court if these issues were litigated. There are other members of the task force that objected to any expansion of those or any diminution, if I can get that word. So this is intended to say that this process does not change other law relative to the authority of communities in their permitting process.
So do you believe that given that what I was describing would be accurate, that if ultimately after this process, the local governments still believe that this location could not meet the local criteria in their land use code, that they would continue, as they do today, to have the ability to deny that permit? And again, the operator would then have the ability to seek redress in district court.
I think both parties would have the legal authority to do what they do today.
Thank you. Sorry to have lots of questions in this, but since this seems to be one of the recommendations that has a lot of momentum, I think it's important to understand all of its implications. And I think I'm probably in a similar position to what John Golden Dubois has stated, that I think on balance, this is probably a recommendation worth supporting, but I am concerned that I don't think it goes far enough to address the two major issues of impacts of multi-well sites and adequate authority for local governments in siting decisions.
Well, I know that there are a lot of things that people would like. This proposal is designed specifically to deal with the area of most conflict. And I believe that area of most conflict is what I'm referring to as large-scale oil and gas facilities, a new term to be defined anew, and the intersection of large-scale oil and gas facilities and urban mitigation areas. That's the focus here. And I tried to take that discrete approach because that's what we've heard most about. I'm not suggesting that this is a panacea and solves everything. But I've tried to deal with that discrete area. And I want to come back and point out, I think I answered one of your questions wrong. You asked whether the authority being discussed for the director of the COGCC is uniform or for large-scale oil and gas facilities. And the language is that it is for large-scale oil and gas facilities. Any other expansion would be for the COGCC to determine. This proposal is for, again, the intersection of large-scale oil and gas facilities.
And just to clarify, my question was whether it would give additional authority to the director to address the impacts of large-scale oil and gas facilities only in communities that chose to go through this process, or would it give authority to address those impacts wherever those large-scale facilities might be next to homes?
I believe wherever those occur.
Ken Wonstolin.
Thank you. Thank you. I guess, Will, in response to your issue of the expedited process from an operator's perspective, I think what I would expect is that if you bring in an application that fits under number 1 here and everything is hunky-dory with the local government, is that goes on the top of the inbox on the Form 2A staff as opposed to going in the queue in the bottom of the inbox. But other than that, I wouldn't anticipate any reduction in other public input there. Secondly, I think on this issue of the additional authority, I mean, obviously the commission cannot grant authority to the director that the commission doesn't already possess. And outside voting to issue an order of the commission, pretty much the director carries all the other authority of the commission today. So I don't think this provision really makes much difference one way or another. And, you know, I would have just stricken it and just say when permitting these things, but it doesn't do any harm. Finally, on the issue of the surface owner involvement, this process is a local government collaboration process. At the same time, there's the Independent Oil and Gas Commission permitting process that has its own notice and consultation provisions that apply to the surface owner relationship. So that is going on perhaps sequentially, perhaps to some degree at the same time. I would think you want to get to a final answer as an operator, so you're probably working at the same time. So when you come down to this location, you know you're not going to then run into a surface owner issue. And keep in mind that well over 90% of the well sites in this state for many, many years have been drilled under surface use agreements. And I don't anticipate that to change should this proposal be adopted.
Dan Kelly.
Thank you. So Ken stole some of my talking points, but and thanks for that, Ken. First of all, Bernie, I'd like to also thank you for the effort and what you put forward here. I do believe that this is a huge step forward. I believe it brings the parties together early, and it brings and I believe that it brings the surface use owner or the surface owner into this conversation very early also, just by effect of bringing the local government into the conversations. And to Ken's point, once you start the permitting process, you have to show where you're at with the surface owner in that negotiation. And that's certainly an issue that the COGCC takes very seriously at this point, from all my experience, at least in the DJ Basin. So just want to thank you again. And to Ken's point, I do believe that the surface owner is very engaged early on in this process. And I do believe that by bringing the local government into this conversation in this urban mitigation area at this earlier time, we've made a significant amount of progress here. So thank you.
Jeff Robbins, followed by Matt Sura.
Bernie,
Thanks for a lot of hard work on this piece. I echo Will and John in that I'm going to support the piece, but I don't think that it. I'm not sure it gets to one of the core issues that I've been focusing on, which is an attempt by this commission to clarify and enhance local regulatory authority. What this is doing is it's giving locals an ability to consult, and consult means to give advice. And I think there's a big distinction between a local government being able to consult and give advice versus this task force, sort of doubling down on where the regulatory authority is on local governments and sort of clarifying that. But I understand what you're doing, and I applaud you for your efforts in getting support from a very disparate group of task force members. So a couple of questions for both you and for industry that's sitting at the table. I appreciate Will's clarifying question and your clarifying answer that this is actually doing two things. One, it is creating this local government consultative process. But then secondly, it is a rulemaking to define large-scale, large-scale oil and gas facilities, and then to give the director an ability to address the siting of large-scale oil and gas facilities. So sort of two things here: consultative process, define these large-scale facilities, and give the director an ability to move them around or be involved in siting. I'm not sure that as drafted, this clarifies that you're doing these two things, because if you look at the process piece, the process part of it all talks pretty much just to the first component. So I'd like you to consider that point. If something comes out of this commission, we want it to be clear because the COGCC will be tasked with implementing it. And so we need it to be very clear because COGCC rulemakings are long and robust, I think is the term I've heard. A second question, and I don't know if it's a question for you or if it's a question for my esteemed colleague, Mr. Wanstolen, or others around the table, but I just want to make sure that industry agrees and acknowledges that the commission has authority to do this second component, which is to define large-scale oil and gas facilities and to give the director discretion to use siting tools to move them around. Anybody?
Perry, I see your card. Is this a response to that question?
Where'd Ken go? It must have been a really hard question because he left.
If I may, in at least partial response to that, Jeff, and for those of you who are not aware of it, I had the privilege of sitting on the COGCC for about 3 years and went through a number of robust rulemaking. And looking at the Oil and Gas Act, and based on my experience at the COGCC, I do not think there is any question but that if it chose to conduct such a rulemaking, the COGCC has the authority to establish rules that govern, that set a definition for these facilities and can apply different rules to those facilities after it defines what they are. I find nothing that indicates to me that they do not have that authority.
Thank you, Perry. I appreciate that clarification.
And Jeff, I would just say that I've had a number of conversations with the director of the COGCC and the director of DNR, executive director of DNR, about this. And they have not said that this is something they can't do. But I will say, I didn't ask them specifically, can you do this? But it seemed very clear to me that this was something that they felt was in their authority.
Thank you for that clarification.
We're ready to move on. Matt Sura.
Bernie, this is more of a clarifying statement, hopefully, that I'd like to get your take on, based on something that Will mentioned. In paragraph 2, on page 2, it says that the agreements can be documented in, among other things, a local government land use permit. It is my understanding that this was a pre-application process to give the local government the benefit of a quick peek as to what they were planning, hopefully before they put pencil to paper and submitted a Form 2A location assessment. And paragraph 7 then, 3, is really just the culmination of that decision, more or less. If the local government doesn't agree where they would like to propose the location, the local government and Colorado Gas Conservation Commission possibly, and certainly the operator, surface owners, can get together, get some mediation, and define where the proposal is going to be. That doesn't preclude the local government then taking that proposal and going through their own process. I mean, I did not see this proposal as only allowing administrative review from the local governments. The local governments still have the ability to bring it to a local planning process and hearings if necessary, if that's their process.
Matt, I'm not sure that there's a question there, but I would go back to the last sentence on the first page. Again, I think everybody's looked at this, but nothing in this recommendation alters any existing land use authority of local governments. And I think that's the response.
I guess I wanted it for the record that indeed this is not, the mediation may just be that, okay, the local government will accept this as the proposal, and it still has to go through the full land use process of that local government.
I'm really not making an interpretation on what the local land use process is or the legality of it. I am just saying that this proposal doesn't change whatever that local land use authority is.
Okay, thank you.
With that, I don't have any other cards up. Any final questions for Bernie? Or Bernie, any last comments on proposal 17?
No, again, I would just thank all of the folks that really spent a lot of time with me and tried to educate me and help come up with this proposal. Thank you.
With that, proposal 17 is finalized. That moves us to 13B. We had a little conversation at the start of this around 13B. Brad Holly, any further comment?
No, I would just say we're happy to take questions on 13B. It sounded like there was pretty good support around 17. Maybe to compare and contrast, I'll just point out that 17 that we just discussed has large-scale oil and gas, which is currently undefined, that will be undefined going forward. They both include the mediation, which has certainly been added, and I think a step forward for local authorities. It does grant the COGCC additional authority, and it requires mitigation options in 17 that could be very onerous to the industry. None of those processes are in 13B. But again, the intent here, I think, is not to write the rule. As Glenn pointed out at the last meeting, we're an advisory board to make a recommendation here on the philosophy, and that's what we're trying to do, and we assume that some of the finer details that we're discussing will be decided and taken up in rulemaking.
Any further questions or comments related to 13B? Bruce Rapp.
Brad, I just repeat my comments that I think to the extent that there's a dispute resolution board that deals with locations, the service owner has to be involved.
All right, with that, if we are ready, we will move on to 16B, Matt Sura and Sarah Berwinski.
Basically, what we have here is very similar to what you've seen before, with the removal of any of the kind of examples, because some of the examples were positive for some audiences and not for others, and vice versa. The intent really was to be able to move forward that conversation, and I think we've had a large agreement and have heard from so many people that it is the proximity, intensity, and scale language that was helpfully provided by Matt Lepore. It continues the discussion into a rulemaking, knowing that while we have made some progress in the time we've had together, we have not been able to solve this problem. And it really is a strong sign, I think, to people that we have taken the concern seriously and we want to address it. So it has been incorporated into Bernie's proposal, and I also echo my support of 17. And I think that we would see the results we want in 17 if it's passed in that rulemaking process. I would want to highlight that what we're trying to do is to really put good location planning first. I think right now, oftentimes the system does allow COGCC to add mitigations. And in my experience, sometimes that just makes a bad location a little less bad. We want to have appropriate locations up front that then have the kind of state-of-art technology that can come in conditions of approval. So that's the kind of pieces, but I do thank Bernie Busher for doing some incorporation and for our industry partners for taking a look at this as well, and it should be an interesting rulemaking. I don't know, Matt, if you had something else you wanted to add.
All right, thank you, and I would note Lem Smith has joined us as Peter D's alternate. Welcome. Perry Pierce.
Thank you. This is Perry Pierce. I have a question, I think, for Sarah. I want to make sure I understand your recent comment. Did I understand you to say that you believe the issues that you are addressing in 16B are covered if 17 is adopted?
Yes, and we would withdraw.
Thank you.
But I reserve the right to do that after the.
Yes, I understand that. Thank you.
Fair enough. Brad Hawley.
No, that was my clarifying question as well. I wondered, just one question, I wondered in 16 if you saw it allowed the COGCC to have final siting authority for all wells or just wells in a certain area like an urban mitigation area?
I think, as you pointed out, part of that is the discussion for rulemaking. For me, I do think that the impacts of these multi-well sites are severe, whether they're adjacent to a high-density area or not. And so I think it's especially important that COGCC has the tools to address those impacts and mitigations wherever they occur, whether it's in an area of urban mitigation or if it's in an area that doesn't have a local government that wants to engage in that process, but it gives them the tools to be able to address some of those impacts.
Yeah, Brad, it does not say anything about urban mitigation areas, and we did that intentionally.
Okay, very good. Any last comments on 16B? With that, we'll move to number 20, Pat Quinn.
I've been wanting to pull out my visual. I have had these in my car for 5 months. I just want to be explicit on what I've been asking for. At the last meeting, once again, I gave a lot of thanks to John coming over to talk to me when we had breakout sessions, because the concept of 5-year planning, I'm not sure is glamorous or as controversial, I think, is what role the local government has. This is Bromfield's master plan. This is our comprehensive map for master plan. Up in these areas here is where the greater Wattenberg area is. Right now, it's basically undeveloped area. And at build out, we're anticipating an additional 20,000 people in here. And as I said, it's the greater Wattenberg area, and there's been no additional well sites planned. And that's the train wreck I've been talking about for 4 or 5 months that we need to avoid. I'm also going to show that for those that have been on city councils and county commissioners will know there's nothing quite like interfering with parents and their kids. And we had the controversy we had in Broomfield was over Sovereign's Wells here and the controversy came out of Prospect Ridge Academy. And so when we're at the local government, we're looking at certain areas where it gets everybody's attention, and we know it gets their attention because they show up. I mean, all government's local, and nothing's more local than being on city council. And so I was just trying to show some of the maps. For example, this Nordstrom well is 2,400 feet, which people in the industry would argue is plenty. From the school, but there are possible pad sites if Sovereign would have been able to consolidate their drilling. We could have maybe mitigated the drilling implications. And once again, these are all things that city councils go through, county commissioners go through. So with that as the backdrop, I'm also going to make another comment that, as I said, I have been a controller and a CFO for oil and gas companies most of my career. I was always the person responsible for doing the reserve footnote. And for those, Dan, I presume because you're an engineer, you've done a lot of reserve footnotes. And I actually, because of the SEC, I would do the reconciliation of standardized measures. So I got immersed in oil and gas reserves, and I understand the process reasonably well as what it takes to get for a 10K, and admittedly that's for public companies, but private companies also have reserves, and they also are required to do it for their banks. And I want to start out by talking about by thanking the people that worked with me the last 2 or 3 weeks. If you saw the red line, you would say, geez, you compromised a lot. And the point I'm going to make is the basic concepts that I said in number 20, and that basically is registration, where all the operators have to register with us. If a local government, a designee or through the city staff wants to get information on what reserves are being planned within that community, it will now, as I understand our agreement is, it will be required. And if you look at the way the wording was written, the 5-year based on reserves, it was written better than I had written it previously. So the basic concepts of registration, requiring all operators to notify us of what their plans are based on their reserve analysis, allowing the city government to do the comprehensive plan overlay, all of those items that I've advocated from September are in my proposal 20, and I want everybody to understand that. That no matter what happens out of this task force, I would hope that we would accept the fact that doing advanced planning and allowing city governments to do what they do so well through their comprehensive plans, and Broomfield right now is in the process of updating its 2005 master plan, that we would all agree to that. Because those, like points 1, 2, and 3 are written better than I had written them originally. And so there weren't compromises on that, and I appreciate the efforts of the industry to work with me on it. When it came down to issues like about mediation and what happens when a dispute occurs, you're going to pepper me, or I suppose you can, the same way we did with Bernie. I didn't feel that was my expertise. I didn't get a chance to go to the local government discussion last 2 or 3 weeks ago, and what I decided to do was I decided to go and refer to, and it's really now 17, I suppose, because the dispute resolution in 17 is the one I'm referring to now. I think I said 13B, because I think 17 is to be the one provide. Those issues and discussions we just had 10, 15 minutes ago are the same issues and discussions, but the concept of advanced 5-year planning, I think, is something new. It's certainly new for the industry. It may be new for the industry in the United States, and it's something I think that would be extremely significant, and we could identify these disputes early in the game and perhaps mitigate those disputes.
Thank you. John Golden Dubois.
Pat, I have a question or two that I think are directed at you, but probably also members of industry that may have worked with you on crafting this, and they are of a practical nature, because I think that the concept of long-term planning should help reduce conflict in communities across the Front Range and well across the state. But in terms of its practical application, I am wondering if you have an answer to the question of what happens when there is a dispute. So you pointed out a couple of schools and some other community assets, open space, I think, as well on your maps. And what I'm wondering is, if there is a dispute, does this long-term planning, in your interpretation and the industry's interpretation, allow for the county or the municipality to move something like an industrial facility to an alternate location that's farther away from its originally intended plan, or that allows other mitigating steps without consideration of number 17? So just on its own, do you think it allows that? And I'd be interested if other members of the industry that might have reviewed this, what their interpretation is as well.
My answer is yes, I do think it allows to move the facilities away. Otherwise, it's kind of, it's not a worthwhile process. I think the question, my answer is yes. The whole point of the process would be to move and talk to the industry and more, and if you have all operators talking at the same time with the same map, I think there's also going to be discussion about getting operators to share surface areas, and what authority the local government has, I think is a discussion that we will have ongoing over the next 24 hours. But the answer is yes. And I think my discussions with industry indicated that the industry understood too, that there would be discussions of, consolidating facilities, in a long range deal. But the ultimate authority through my proposal would be to go through mediation first and then through the COGCC, which would have the ultimate authority.
Jeff Robbins?
Just hold on, I just want to check. I want to make sure that that Pat's interpretation is shared by industry, because it matters to me to understand the intent on both sides of this proposal. So I know that members of industry helped to craft this proposal, so I'd like to have a sense of where you are on what this means and whether or not local governments would actually have the ability to take facilities and propose new locations and move them away from those assets within the community they want to protect.
Dan Kelly, a response to the question?
Thanks, Dan.
Yeah. A little bit on an island here maybe, but no. Pat, again, great job. In the last meeting, it didn't get a lot of interest from the folks that were in the room, but I came over and listened and appreciated what you were doing here very much. And I don't think this gets separated from 17. My view of the world is that this really complements 17, that anytime that you're putting lines on a map inside of a municipality, the earlier that you can get that to your local government and to the right bodies inside the local government, the better off we all are going to be, because it engages the conversation so much earlier, and it gives both entities, the operator, and I'll even say the three entities, it gives the operator, the surface owner, and certainly the local government, the ability to see what the plans are, allow them to have the conversations internally, and for measures to be not determined, but at least calculated and questioned at a much earlier time than what we've seen in the past. And part of that is that this whole technology and this whole process is still developing so quickly and moving forward that some of these impacts we didn't see coming. So I think to this point, I think that the industry does know that the intention here is to get out in front of this, to work closely with the local governments, to follow the process to the point where you get into the siting issues, and if they come up, you work very hard with your local government and your COGCC that brings more tools to the process and brings more experience to the process than maybe that local government may have in particular cases, and works closely with the operator to bring those forward. And then, you know, as this gets resolved, nobody wants this to go all the way through to court. So you work very closely with your COGCC, and if it does end up at the commission, I think that the operators understand that there will be impact there, and we'll try not to take this all the way to hearing. And I can assure you it's not our intentions to take things in front of the COGCC on a, you know, on a normal basis.
John, to respond, and then Perry, also to this point.
Dan, I appreciate that, and I agree that having more notice, more involvement earlier should resolve some conflicts. I guess I'm still trying to find an answer to this question of, does this allow local governments in those initial sightings and issues that they want to address with industry to be able to say, look, really right there is a protected area. It's an open space. It's a school. It's whatever asset they feel they want to protect. Does this allow them in this process to move these industrial sites to other locations? I'm hearing Pat say yes, that's part of the intent of what he's trying to get at in some instances. And I'm hoping for a clearer answer from the industry so that I can understand what we get at here. Because I support the concept, and I want to support the proposal. I feel like I want to know what it means before I am able to make a decision on that.
Well, the key, I mean, I suppose we did the key words here is obviously the local government has the right to propose different locations. The question comes down to is what happens when there's a dispute. I mean, the whole intent of what I'm proposing is that now, the local government comes in and looks at these wall sites and sees could they be better located? Perhaps in a lot of cases, particularly if you're dealing with the larger operators like Noble and Anadarko, they'll work with you. They'll with this tool, they'll work with you. They'll move out of key, locations that you consider to be sensitive. But I haven't, this certainly does not give the local government the authority to actually move that without the consent of the oil company.
Perry, did you have a follow-on to this point?
I think Pat may have come close, but let me try to provide at least my view of this thing, John, because at least the way I understand this. I understand recommendation 20 to be an encouragement of a planning process. I do not take recommendation 20 as a determination of anyone's property rights. For instance, I do not understand 20 to allow a local community to instruct an operator to move a location to a location that does not exist or is not available. And that might be a problem. But I think there is a body of law which Justice Corliss and others have provided to us to settle those disputes, and I don't understand recommendation 20 to change that. It is, in my opinion, addressed to the front-end planning process rather than dictating or forbidding any outcome.
Barry, thank you. And I guess where I'm struggling a little bit here is in other community planning processes with folks representing home builders around the table and others. There are opportunities for communities to lay out their community values, to set plans, and to protect certain areas within their boundaries that are important to them. And I just wanted to see if this allows for that same kind of planning or if it's different in this particular context.
If I may just give my understanding of a critical difference. Natural resources are located where they are. If a local community planning processes forbids a land use in one place, You may be able to move a store or a dry cleaners or a filling station or anything else. Resources cannot be moved. And so I think there is a restriction in this area that does not exist in other commercial zoning applications.
You know, part of the premise of this, though, when you're looking at it, is that that the advent. I mean, you know, Brad and Anadarko took us on a tour of their facilities where we're able to go 10,000-foot laterals. And my understanding, what's going to look at the reserves, that a 10,000-foot lateral is more economic. You know, it has a better rate of return than one vertical well. So I would point out that the definition of, you know, where those reserves are has changed, and that's part of what I'm proposing. And I can't imagine, once again, Anadarko and Noble not taking advantage of the fact that they are doing laterals. So the definition of accessing the resource has changed even in the last 3-4 years.
Okay, with that, I had Ken Wonstollen, followed by Will Tour, and then Jeff Robbins.
I think Dan and Perry has stated it exactly right. There's nothing in this proposal that attempts to empower local governments with more authority than they have today. It doesn't affect that one way or another. So this is a proposal that will prevent, hopefully, or allow local governments not to have a comprehensive plan that doesn't take into account the potential for future drilling, as the map that Pat showed us did in Broomfield. So hopefully the maps in the future will take into account the potential for development. And it categorizes those potential drill sites in a way that puts operators on notice that drill site A may be a fairly easy lift through both the local land use process and the Oil and Gas Commission process. Drill site B may be a little more difficult. It's going to take some negotiation. And drill site C is going to be a big hurdle to get over. And maybe the smart operator starts looking for an alternative location. Maybe they use the tool provided in number 10 to find that location. But this is a planning proposal and not a power proposal.
Will Tour.
Thanks. And Pat, I really appreciate the concept and all the work going in here. I have a question and a suggestion. The question is, the language in this draft refers to municipalities rather than local governments. So is that intentional, that it excludes counties?
Yes.
And can you speak to why?
That, you know, it was a discussion, and once again, you know, we all come to this this task force based on our own backgrounds, and you know, and I guess I would point out the counties aren't necessarily asking for this, and I certainly haven't heard Boulder County ask for it. And you know, I guess my attitude when there's a sensitivity to having the counties, you know, have access to this process right now. And part of my comment during that discussion, because a lot of this discussion occurred in the last 4 or 5 days, is I'm frankly not, you know, I'm aware of Boulder County's comprehensive plan going back 25 years ago when we were part of Boulder County, but I don't know what kind of comprehensive planning occurs within the counties, because Broomfield is a city that runs a county. And you know, it was also pointed out by CCI that they've not asked for this ability. So it was a little bit difficult for me to advocate for the counties to get this ability, because I wasn't aware, I'm still not aware that they're asking for it.
You know what, I guess a thought on that, as I understand this proposal, it is purely voluntary. It's upon the request of a municipality. So I don't think broadening it to include counties would impose it upon any county. It would simply give if I'm understanding this, a tool. And given the fact that along the Front Range, where most of this conflict is taking place, you know, much of the drilling is taking place in unincorporated counties, often very close to municipalities. I'd like you to think about the potential of amending it to include counties. And it certainly is the case that CCI clearly has taken the position they have taken. That does not represent all of the counties in the state. And I don't believe it even represents those counties with the majority of the population in the state. Second question or suggestion is the prior discussion was helpful for me in sort of clarifying what this does. And I would describe it as being more an information sharing and consultative process rather than a comprehensive planning process. And this sort of may get at different interpretations of planning from folks in the local government world and outside the local government world. I certainly come from a background in which when we adopted when we would go through a planning process and adopt a comprehensive plan, that then had the force of law. We adopted it into our zoning code, and you could only apply for land uses, do a land use application that was compatible with the land use designation in a comp plan. So I don't, given what was just described, that it's not intended to give any additional authority over siting, I would be more comfortable if we move forward with this to change the name and describe it really as a recommendation to share information earlier and to do a consultative process on potential oil and gas locations, as opposed to describing it as incorporating them into the comprehensive planning process. Because I do believe that there's great value to that earlier information sharing and consultation, but I don't think, I think it, in my mind, doesn't accurately describe it and will be confusing to people if we describe that as being comprehensive planning, because it is very different, as was described, from every other industry that we regulate through comprehensive planning. So I don't know that it would change the substance, but I think the name would more accurately reflect the substance.
Well, Will, I hear what you're saying. I guess my point comes down to, and I just think in terms of what would have happened in Broomfield had we done this 2-3 years ago before Sovereign came with its application, that resulted in all the controversy. I guess the point I'm making here is if you go down to item 3, we say at the last 2 lines, that sites where it anticipates significant conflicts with current and planned future uses as indicated in the comprehensive plan. So my intent here is that we will identify areas where there are conflicts within the comprehensive plan. I mean, I don't know a planning staff that won't do that. And once again, I think the real issue gets down to, we're going to identify where these conflicts are going to occur. The question comes down to how it gets resolved. And that, frankly, is the $64,000 question that is going to overhang us all day. But the point here is to identify where conflicts occur, and the local government's going to say, they're going to say to the operators and the COGCC that our comprehensive plan has a conflict here, and we don't think these sites are acceptable. And then what has been proposed in here, which I concur with right now for the sake of getting this moving, is then a mediation process occurs, and then then it goes to COGCC. That's certainly, I mean, I don't think there's a planning staff that goes through this that won't tell you these are conflicts of the comprehensive plan. So I view it as an update of the comprehensive plan.
All right, I had Jeff.
And I want to leave the title.
Thank you. Understood. Jeff Robbins.
Thank you. Pat, I want, thank you for working hard on this, on this proposal. I think it is somewhat different from where you were earlier. I tend to agree with Will that it's more information sharing now as opposed to comprehensive planning. And I want to actually point out, Perry, your comments that this is an encouragement of a planning process. It doesn't allow local communities to move a location. The body of law about preemption has not changed. Front-end planning process, and I note that Mr. Wanstolen said you stated it entirely right. And for once, I could agree with both of you. Because I think, I do. I mean, I think this is information sharing, but I don't think it's a planning process. And so, with respect, Pat, and in fact, I'm not even quite sure how mediation works when you're dealing with comprehensive, with sort of planning and information sharing. Just like if you have a comprehensive plan that says you can't do industrial here, unless and until someone comes in with a specific application to do industrial, you actually don't have a conflict because it's the actual application, which is, I think, what Harry was getting at. So, I think, good effort, but I'm not seeing at the end of the day, I liked your earlier approach better. I liked for real comprehensive development planning as opposed to where we've ended up with sort of more of an information sharing that's really, not doing as much. It's not as far, I think, as your earlier proposal. And I understand that we're all trying to get to a point where people can, all vote yes on some things, but, those are just, my comments on that. And again, I appreciate the hard work.
Gwen Lackle.
Thank you, Gwen Lackle. Just speaking to the concern about including counties as well as municipalities. Yes, we did receive a resolution from CCI. The backstory, and I was there for that vote, it was quite controversial. We will be receiving a letter from a number of counties that disagreed with that and that are seeking more clarity in local government authority. And also of note, CCI has since completely revamped its bylaws in order to avoid such controversial issues in the future.
Thank you. Steve Marino.
Yes, Steve Marino, Weld County Commissioner. Pat, I want to commend you again for the recommendation here because this has been a lot of the heated conversation about the urbanized area versus the rural area. And to hear that the process would include the communication and really the dialogue, the education to the collaboration and the upfront process there before the COGCC actually does the permitting here. I think this is a thought out issue from what you're saying here to have some insight to, how the urbanized areas can address some of these concerns that are out there from many of the comments we've heard in the public comment there. But as far as the comments to inclusion with the counties, I respectfully disagree with the recommendation to include the counties there. For instance, in Weld County, again, as I stated from the very beginning here, we are the epicenter of the production right now. What's going on with 80% of the production coming out of the county and over 50% of the drilling going on in Weld County. And I believe things work very well and have been modeled extremely well in Weld County with what's going on in the communication and working with the industries out there. I don't think that's an issue. Speaking from a firsthand experience of serving now as a county commissioner, early on, I know I'm early into the process as a new county commissioner, but I really don't see the need to add that in there. And if that is added in there, I would not be in favor of supporting it. Currently, I am strongly in support of this the way it is currently written. Thank you.
Perry Pierce.
Thank you, Perry Pierce. I want to circle back. I also appreciate it, Pat. And unlike some, I think you have made substantial progress in coming up with a recommendation that will allow more agreement, and I appreciate that. Something Will said was enlightening about the problem. I understood Will to say that under full or fully developed or historical comprehensive planning processes, that is the concern, or at least a concern, of the natural resources industry. We do not think it is appropriate to have an absolute ban. We support the planning process and trying to allow resource development from alternative locations and move things around. We think that's very healthy. But there will be instances in the future that if a local community is able to ban an oil and gas drilling location, we will be forced to proceed directly to the courthouse without engaging in any sort of constructive dialogue and planning process. It may be an infrequent occurrence, but we would like to avoid that, and for that reason, I think your redrafted 20 is an appropriate step. I appreciate it. Thank you. Thank you.
Thank you. Any further comments on proposal number 20? All right, with that, we'll move on to number 14. I will note, we're going to keep pressing forward until the lunch hour. So if you need to take a personal break, please do so, but we'll continue the conversation. Number 14, Matsura.
Thank you. I'm going to use this opportunity to address something that Perry just mentioned. I think I heard you say that if a local government refuses to give a permit to an operator that has applied for one, that is a ban? Is that what you said?
May I?
Yes, please.
No, that is not what I intended to imply. I understood Mr. Tour to say that under comprehensive planning, a local government could take a specific tract of land and say, under any conditions, you are forbidden from conducting some activity on that piece of land. Now, that is not a ban other than for a particular piece of property, and I view that very differently. But I am concerned that no planning, no exchange of information, no exchange of views, no process makes any difference from what I understood Will to say a full comprehensive plan would provide. That there's no escape of that. It's just, here's a piece of property and you can't do something on this piece of property. Now, I think that leads to whether the lawsuit is taking or whatever the lawsuit is. But I think it leads directly to the courthouse without encouraging coordination and discussion and compromise.
Will Tour, is this to this point?
Yeah, just a clarification. As I understood this recommendation, that process of information sharing and coordination and discussion would be happening up front in the development of the comprehensive plan. So thinking of the earlier version of Pat's proposal, that I think was more like traditional comprehensive planning, that in fact, that discussion that you're referring to would be precisely what would take place during the development of the comprehensive plan. The local government, after going through that process, would adopt a comprehensive plan map that would identify what locations were appropriate and what locations were inappropriate. Presumably in that process, you would be looking at what are the alternative ways of reaching those resources. My sense of where Pat started with this is knowing that we can go 10,000 feet now. In the future, we may be able to go further. That's brought a lot more drilling into conflict with folks, but it also gives a tool to be able to move that drilling into places where there will be less conflict. And so I don't believe that a local government comprehensive planning process would go forward without the involvement of industry in providing that information and looking at alternate locations.
Okay, with that, I think we are ready to move, Matsura, to your proposal 14.
Yeah. The word ban is a very loaded word, and I think that finding alternatives to a location that is chosen, or finding a way to allow for the industry to access a mineral reserve that they have a right to access is not a ban. It is doing good planning, and that's what I hope that your proposal is going to lead to, and certainly Bernie's and Brad Holly's as well. This is something similar. It's very similar to what you've already heard from Bernie Busher and from Brad Holly, and I just want to illuminate the differences. The first is that under triggers, it allows for a relevant local government to choose areas to have this process of a residential drilling plan requirement applied to. And that's because clearly there are areas that are still growth boundaries. Urban growth boundaries exist in most cities on the Front Range. There are places where they know that they want them to grow. Sometimes there's even platted subdivision, but they're outside currently of the city boundaries. So, or they don't meet the requirement of, quote unquote, an urban mitigation area. I think that those types of areas should be able to be planned and have this process applied to. I also changed the definition of relevant local government. The relevant local government definition that is currently in practice at the Colorado Gas Conservation Commission is that you actually have to be inside the jurisdiction for it to apply. A recent example is the town of Windsor, who felt that they had to annex a piece of property that was an enclave. It was completely surrounded on all sides by the city of Windsor, but it was Larimer County. And they were informed that they would not have the ability to request a hearing because they weren't considered a quote unquote relevant local government because it wasn't within their boundaries. What this does is just say, if you were a municipality that is within 1,500 feet of the proposed location, that you can indeed have that standing as a relevant local government. And this is going to come up in a later context when we talk about standing. The other major change is that it just says that the duration of the negotiations between groups listed above will last no longer than 180 days. Again, that was a number that of many that Matt Lepore pulled out, and that was the largest number, but the 90 days for negotiations that Bernie has proposed is something that's acceptable. So I'll entertain any questions about it.
Mr. Dorr? Okay, any other questions for Matt? Or comments on this one? Okay. Going once? All right.
Sorry.
Oh, Brett.
Sorry.
Mr. Holly.
So Matt, in light of what our discussion on 17, do you feel like that 14 is still distinct enough that it stands alone, or do you think that the components that we've talked about in 17 could be incorporate and pick up 14 as well?
I think it's likely that we could I'll withdraw 14 if 17 gets support.
Thank you. So the question was, does 17 cover the components of 14? And Matt, your answer was?
If 17 were to get support from this group, I would withdraw 14.
Any other questions on this? Okay, we will move on to number 7, which is Russ George's proposal that also had undergone some revisions since the last meeting.
Thank you. Number 7 sort of continues to subscribe to the important theme that we've all been hearing for these many months, that local government and the citizens in local governments want to be heard. And the sooner they can be heard in a potential oil and gas operation, the better. And so this number 7 responds to that request that the public has brought to us many times. And it does so by acknowledging what we also have heard through these months of what has worked, and that is planning, master planning, comprehensive planning, working together to agreement, memorandum of understanding, various levels of collaboration, consensus building, and mutual decision making. Those are incentives that almost always work in this kind of a democracy we have, when everyone tries in good faith to get to a solution of these competing values. So 7 continues to try to incorporate those values in a fairly modest way of saying when an operator begins to plan towards a drilling site and ultimately any type of operations site, that the pathway to permits, required permits, shall be parallel, shall be begun both at the local level where local permits are required and at the state level where state permits are required. So that's a key point that we've heard, that no longer would an operator go only through the state process and then at the end of that say, oh, and by the way, we'll come over to local government and have that conversation. That would not happen under this proposal. So we've tried to incentivize everybody to be at the table at the same time and work out these common concerns. And where the local government and the operator or the applicant for the permits can agree, then the incentive to the operator to be agreeable is that once permits are granted by the local government, it helps move final permitting at the state level quicker. And so that almost always is an incentive to operators to be able to move faster through the bureaucracies and get to the business they're in. The changes from what you'd seen earlier, simply some refinement of language in a few places that we're talking about the siting of drilling and production permits, and the permits are both state and local. And then more significantly, the addition of a mediation or alternative dispute resolution concept. We've also heard the value of that. It shows up in many places. And I've inserted what I think is common language to be used here as well. One more opportunity, an invitation for the players to try to work things out. There seems to be a great reluctance to take these cases to the district court. And that's probably a time, cost, and predictability discussion, as it is with almost any major case that has to be litigated. Everybody has incentives not to do that. Nothing in this proposal changes the rights of these parties to do that as exists today. Everyone remains free to choose to defend their rights or advance their rights in district court. But this merely sets up an array of opportunity, invitation, incentive to solve the problem of the conflict of equally competing values to move on. On the question of adding surface owners, Brad, I'm still anxious to know how that plays. Certainly care about the surface owners' rights. I'm not sure I've done anything to reduce the rights that exist today. And if you could help me understand where they would fit in this process, we could have that conversation. As I think about it, it still doesn't, I can't get it clear, particularly at the mediation level. When you add the surface owner, have you now added 3 parties instead of 2? Is that third party then on equal standing to select mediators to participate in the discussion and to refuse or to agree to a solution? If that's what you mean, we need to be clear about what could then happen. You could have a situation where the local government is satisfied, the operator is satisfied, but the surface owner in this conversation could simply have a veto at that point and force everybody into a different result. I want to be sure that that's a place we would want the surface owner rights to exist, but we can talk about that. And I would appreciate hearing other people's views.
Okay, Bruce, why don't we go to you first since.
I still my card up last. I'm happy
You,
to talk.
okay.
I don't want to.
All right, we'll go to this side of the table then. Ms. Corliss and then Matt Sura.
So Russ, I have a few comments, some of which may address the surface owner participation in this process, but I don't want to start there with your permission. The first thing I want to note is that the two proposals that we've talked about so far this morning that seem to have a significant amount of support only relate really to urban mitigation areas or to multi-well sites. This proposal, as a number of others that we will now begin to tick through, are broader. So I wanted to make that point preliminarily. However, the second piece that I really would like to concentrate on, Russ, is to understand the process that you contemplate in E. I understand, I think, up to E exactly what would happen, but E is where the rubber meets the road, where the local government is not willing to issue a permit, or as you say, the conditions are, in the view of the operator, unreasonable. So as I understand what you then would suggest would happen, the applicant offers to engage in mediation. If the local government agrees to it, then they go to mediation. If the local government does not choose mediation, or if it doesn't result in an agreement, then either party can go to court. What is the role of the COGCC in this process that you contemplate?
Probably at that point, as we're talking about mediation, it's strictly between the local government and the applicant. The COGCC process is sitting on the sidelines at that point. The operator can continue to function in parallel even during this time, but can't. The state would be prohibited from issuing permits while this local process is in place.
So the state couldn't issue a permit until there was either a permit at the local level or an order of the district court?
No, or well, I think, let me back up. Here's the way I see it. When the state will not issue its permits until we have been through at least through the mediation conversation that's here. If mediation results in an agreement, then both procedures continue forward. If mediation fails, then the applicant can choose to continue to proceed with wherever they are in the state process. But the state permit process cannot be complete until litigation has settled the issue.
Okay, thank you.
Why an applicant would go ahead with the state would be a factual discussion. What work are they working on? What details need to be worked out? Is there some planning? Is there some drafting? Where is it? That's just a factual discussion. It's not a determination of final approval.
Okay, and then I think I will park the surface owner participation conversation until we get more into the substance of that. I think we're going to start down that path with 21B, and I'll make some of my comments there. I think I agree with you that I'm not entirely sure that we need a specific inclusion of surface owner rights in this particular proposal, the way that you have it framed.
Okay, thank you.
Matt Sarah.
Thank you. Jeff Robbins said at the beginning of this meeting that one of our charges was to hopefully enhance and clarify local government authority. And working for local governments, I think that it is needed, both enhancing their authority and clarifying what it is. I feel that in total, this is actually diminishing local government authority. And for the way it stands now, I'd have to vote against it. The way that it diminishes local government authority is really three ways. And the first is this premise that the land use decisions have to go in parallel or together, both Colorado Gas Conservation Commission and the local government process. And this is far different than your earlier draft that suggested that the local government process would go first. And I know that there are some local governments that currently have a procedure that they are expecting that they will be going first. And I'm, taking away their ability to do that and make their own decisions, and really is attacking the sovereignty of local governments, and their ability to do what's best that they think for their constituents. The next is in Part E, the proposal allows the Colorado Gas Conservation Commission to determine if the local land use restrictions are prohibited by law or unreasonable, or if that is a threshold issue for an operator to bring forward a concern to the Colorado Gas Conservation Commission. Again, I'm just not sure that the COGCC is in the position or is empowered to make those determinations. Clearly, they don't have the ability to determine what it is prohibited by state law. That's a district court's job. And then finally, on Part G, it says that the Colorado Gas Conservation Commission is going to determine the timelines for all aspects of this rule. And if you are trying to have the local government and the state government go on parallel tracks, you're really tying the hands of local government to be able to take the time that they believe that they need. Local governments are all over the map as far as their processes for permitting oil and gas development. There are some that have as a use by right. There are some that have 2 public hearings, and there are others that have an administrative review through an MOU and a memorandum of understanding. I would be hesitant to shoehorn all local governments into a timeline that is designated by the Colorado Gas Conservation Commission.
Russ, did you want to respond to that?
First of all, I think the language is simple enough that it speaks for itself. And I disagree with you on virtually every point you've made.
Okay, Mr. Rao and Mr. Wansel next.
So I just wanted to take this idea of the surface owner out of the esoteric and into the reality. Ken, if you don't mind me using you as an example, and I'll use myself as an example as well. The surface owner is someone who owns the surface of the property that's going to be impacted by the oil and gas operations. Whether you're a farmer, you're a land developer, you're a homeowner, you live on a large suburban ranch, whoever you are, right? And the operations of the oil and gas industry will definitely affect you. And so to the extent that there's a mediation amongst the parties to a dispute, it is proper and I think critical that all the parties to that dispute are involved in the mediation. And so, Russ, your question is a good one. How exactly do they operate in this process? And Justice Corliss, I appreciate and support your other proposals that address this issue, although I think to the extent that we have proposals that move forward and others that don't, it's important that we address this issue in each of them. And so to answer your question directly, if the dispute is over where a surface location will occur, whether it's alternate locations on an individual's property or alternate locations amongst multiple property owners, and that dispute is going to be resolved and or mediated through an alternate dispute resolution process, it's inconceivable to me that that surface owner wouldn't be part of that process. I think the only circumstance wherein they wouldn't necessarily be a party to that process and have the same rights as any other party to that process would be a situation in which they have agreed with the operator through a surface use agreement to the location or locations being discussed. In all other respects, I think it is critical that they be involved.
Mr. Wanstellen?
I'll join in Mr. George's comment on disagreeing with Mr. Sir's characterization of this proposal. I don't think it does damage to local authority. And I guess I'll just comment that on Part F, the ability to continue going through the state process when you've reached an impasse at the local level may be very important to your potential litigation, because if you want a preemption claim, you better have the state permit in hand. Otherwise, it's not ripe for litigation on preemption grounds at least. So I think that's an important feature of your proposal, Russ.
We'll come over here to Mr. Fitzgerald and then Mr. Busher and Mr. Tour.
Jim Fitzgerald. I don't know, Russ, if you can answer this or somebody else can answer it. I'm just becoming, Jeff has assured me that in a case where they go to district court, the damages you don't pay for any more than what your own lawyer costs. I think that's what you told me. And I'm worried, how much does mediation cost? And how much would it, if they decide to go to mediation? And I'm just worrying if the costs are going to begin to deter counties from appealing or insisting on mediation. Does anybody know that? Is it an insignificant thing, or in reality, is this something that'll come up on a local level?
I think that goes to me. It depends on the process for sure, Jim, but mediators should be a whole lot less expensive than a court proceeding. A party may proceed without an attorney in a mediation session, and if there's one mediator, then that mediator charges on an hourly basis for the time that he or she spends on the process, and it's divided equally. I think that's the way that all of these proposals are framed. If there were 3 mediators, the same would be true. I can't tell you right at the moment what mediators are charging per hour. We could call some of the dispute resolution companies and get you a ballpark, but my guess is it's probably, Jeff, Matt, Ken, somewhere between what, $350 and $500 an hour for the mediator. Does that sound about right?
That sounds about right. I just finished one in a fairly complex commercial setting. My half of the bill was $2,400, something like that.
Yeah, so it's not cheap by any means, Jim, but it's a heck of a lot less expensive than going to court.
Thank you.
Bernie Busher.
Thank you, Sarah. Russ, I like what you've done here. I always am amazed that you can handle in a page things that it takes me 4 pages to handle, and I just shake my head and say, wow. Your proposal, as I read it, applies to all oil and gas activities and to the entire state, not limited as 17 is. And I think they play well together. The only thing I worry about is whether or not there is conflicts in the areas of urban mitigation areas and multi-well facilities. In those 2 areas, do you see that there are conflicts between the 2 proposals that we need to work on?
Thank you, Bernie. You bring a point that has cost far more sleepless nights than it can possibly be worth. And all of us should have been thinking about today and what do we do with this long list of ideas because of how we develop them. And so I don't have a clear thought about how to do it, but I will tell you where my thinking is at the moment. Because all of our duty is intended to lead towards mastering an enormous amount of information in a short period of time and to make recommendations forward. It isn't that, well, conflict may not in itself be a concern. Certainly, we've got conflicts in the plain language of a number of these. I'm not sure that is a problem because we don't know where any one of these will go. In almost every case where it will go involves a public process where affected parties are entitled to participate. And one of the things that those processes tries to do is to not create more problems, but resolve, simplify, blend. And so in my mind, I want to look at these as concepts and say, when you look at it from this standpoint, here's a concept that was advanced by us. If you want to look at it a little different way, here's how we looked at that. And you can say that with virtually everything we've done. And in my mind, that's not a problem. So the simple answer is yes, I think in a playing out of detail, we'll have to make choices, whether we go what direction mine implies or whether we go to what direction you're either specifying or implying. I really appreciate the detail, and I chickened out on detail because it does get very difficult very fast. And I couldn't get my mind wrapped around an overlay where we would take these 4 or 5 that we've always had on each subject and lay them down over each other and begin to work out those points where we cross and diverge. I just couldn't get my mind there. Somebody gets to do that. If we do move forward a number of these that are of this type, somebody will get to do that. But your public processes are designed to handle that kind of complexity.
Russ, if I could respond to that, I struggled with exactly the same issue of giving, both of our recommendations are directed to the COGCC, and giving them enough direction so they could clearly discern our intent, not trying to do their work, but making it clear on their intent. And I think the intent of yours is clear, and it's my feeling that they do play together well. And if there are subtle, mostly process conflicts, that the folks, Matt Lepore and his team, will work that out.
Great. Mr. Tour, last comment on this one.
Thanks, and I want to add my thanks to Russ for all of the work that he's done on this and the remarkable brevity of it, which is refreshing. Despite that, I'm still able to be confused by it, so I have a number of questions. One question is on the language in F, where it states that the applicant may continue complying with requirements of the permitting process pending litigation. And does that simply imply that they can move into the permitting process, or that if they go through that permitting process and are granted a permit, that they may proceed to drill unless, regardless of whatever local government permitting process there is, unless the local government is able to go to court and stop them? I'm not sure I understand the interpretation on F.
My understanding is that you have to have permits from both local government and the state in order to drill. I'm not recommending we change that. The only alternative to that is when you cannot get a permit, or this is the operator I'm talking about, when the operator cannot get the local government permit or cannot accept the conditions of the permit. The alternative is to get a court decree to allow the operator to proceed only with the state permits. I'm not recommending we change that in any way. Remember, one of the essence of the incentives in this is to allow the operator, should he choose to do so, expend the resources necessary to go through both processes at the same time. There's probably economic value to that. There's probably a number of incentives involved in that. And when the local government process has stalled, My point simply is that there's no reason that should also stall the rest of the work, because time matters. But it's a choice the operator can make. It does not guarantee that the operator can get the permits and go forward with drilling. I don't think that's the law today, and I'm not proposing to change it.
So to make sure I understand that, under F, it's simply stating that the applicant would be able to go through the state permitting process, but they still ultimately would require both state permit and the local permit. And if the local permit is not granted, they would then have to go to court in order to argue that the local decision was inappropriate.
Yes, I believe that's the law
Okay.
today. Now, there's nothing during that time period that prevents all of them from coming back and talking to one another again, which would then result in a negotiated agreement that causes the local government permit to issue, which then really makes some sense about having gone ahead with the state process, because you've saved some time.
Okay, then second question on G, and I think it gets at a question that Matt raised. So is this implying that there would be a state rulemaking that would set the timelines for the local permitting process?
It is inconceivable to me that the state rulemakers, given their attempt to put this concept into play, would do anything other than acknowledge existing timelines in local government land use processes. This is not intended to alter that.
So I think it would be important to clarify that if the intent is not to have the state set the timelines for the local government permitting process, I think that should be very clear, because that would be a significant change that I think would raise a lot of local concern. And then the other question was on C, where it states that the applicant, will begin the local government and the state permitting processes at the same time. So what if the local government has a process that either requires them to go first through the local, or that would not process a permit until after it had gotten the state permit? Would this be directing the local governments that they must have a process that moves in parallel with the state, or simply is it saying to the operator that if the local government has such a process, you have to do them both at the same time?
First of all, I don't think the Colorado Oil and Gas Conservation Commission has the lawful authority to change local land use regulations. Okay, so if I'm right about that, that's mostly the answer to your question. The rest of the answer to your question is that the principle I was working from was just the opposite. That I was trying to address the case where local government is left out and only the state process has been utilized. This fixes that. It doesn't probably close the hole it opened that you're now highlighting. And so we'll see if we can fix that. But you see how I fell into that hole.
Yeah, no, this is very interesting, and I really appreciate what you're trying to do here. I think that where I end up on this is it's confusing enough to me what it would really mean, and I have some concerns that the pieces that are most significant here really could easily be interpreted as an attempt to put more state limitations upon a number of aspects of the local authority. That I'm much more comfortable with the approach in 17, and would think that we might want to look at expanding elements of that approach beyond those urban mitigation areas if we feel like it's important to address decision-making in other areas. But really respecting what you're trying to do here, I think this is one that I'm not going to be able to support, because I think it could be interpreted in ways that would be a step in the wrong direction, even though I don't think that's what you're really trying to do.
It's not what I'm saying either, so surely that goes for something.
All right, any further comments on number 7? If not, we'll move on to number 12 and number 12A.
And with apologies, Doug is out of the room. I guess we'll just sort of start circulating. I have a proposed change, thanks Bernie, to 12/12A, and let me set the stage a little bit. If you remember, originally 12 was the dispute resolution panel, and then a provision that dealt with citing authority. In the last go-round, I bifurcated those into 12 and 12A. It is my considered view at present, given the fact that mediation has been subsumed into a number of other proposals that appear to have support, that 12 no longer needs to be a standalone. 12A, on the other hand, I think absolutely is still up for discussion. And as a predicate to this conversation, I would say a couple of things. First of all, and I'm not a big one with quotes, but right at the moment it seems appropriate. Supposedly, Justice Holmes said that simplicity without understanding is worthless and simplicity with understanding is priceless. This is very simple. It's an effort to distill what I think we've just been talking about with Russ into a much more straightforward, simple proposal, but then also to add back in the mediation piece, which I sort of conflated with the original 12. So I'll just read this for those people in the audience who don't have it in front of them, or for those people listening in. In those jurisdictions where the local government has enacted siting regulations concerning the location of oil and gas wells or production facilities, a COGCC approved APD or location may not be acted upon until the location of the well or production facility is approved by the local government. In the event the COGCC and the local government decisions over a location for a well or production facility are in conflict, the operator or the local government may request mediation as described in Proposal 17. So this is an effort to distill out the two basic premises that I think we were just talking about in 7, namely that it is our expectation that an operator would need permits from both entities before going forward if the local government does permitting, except in the circumstance where the conditions are unreasonable or there is a broad-based, I won't say ban, a broad-based prescription. And in those instances, the process then goes through mediation with, as 17 suggests, ultimate recourse to the district court. So I leave it to you to determine which side of understanding this falls on, but it's an effort to really be very simple about the premise that we are forwarding.
Mr. Ron Stolen? And Bernie and Will, are your cards still up?
Can I ask you to clarify, may not be acted upon? What I presume you mean you cannot, it says a COGCC approved permit, so you've got a state permit in hand, it may not be acted upon, means you can't go drill with that permit.
Right.
Okay, so I guess I have actually faced this situation on occasion, and while I would recommend to the vast majority of my clients that they do not proceed without the local permit, there have been and there will be cases where you're facing imminent lease expiration or some other contractual obligation, for example, or loss of a drilling rig, where the operator may decide, you know what, I'm going to go ahead and take the risk and drill. The local government can seek an injunction. At that point, the local government has to show likelihood of succeeding on the merits, possibly a bond. So I think this is taking away an existing legal option that rarely, if ever, is going to be played, but it's one I would not want to see be removed.
How do you think it takes it away, Ken?
Well, you said it may not be acted upon, so you now have a state rule saying you cannot use this permit to go drill your well until the mediation and subsequent litigation process has concluded, and that's going to be some months out. So if there's some imminent commercial business reason why that operator says, I need to drill, I'm going to lose a very valuable lease, I'm going to lose a deal, I'm going to lose a drilling rig for the next year. I'm going to take my shot to go drill under my state permit and let the local government take me to court if they want to stop me.
Okay.
Mr. Pierce?
Goodness, there's plenty of rigs.
Thank you. This is Perry Pierce. I have a question for you, Becky, and I just don't know enough about local laws and regulations to answer my own question, so let me try. Is there an instance in which a local community, in your words, may have enacted siting regulations concerning the location, but there not be a requirement for a permit from the local jurisdiction?
Jeff, Matt, what's the answer to that? I don't know either, Perry.
The reason I'm sorry, the reason I asked the question is because one of your follow-on comments referred to the permit. If you need a permit from both locations, I understand that. But I don't know if this language goes beyond that or not.
So Perry, I'm sorry, but
okay,
I don't know that I get the question, but I'll.
Okay, it's peculiar, Jeff. I admit that. And might there be an instance in which a local government adopted a siting regulation and had it in place, but there was no permit requirement from the local jurisdiction? I don't know that that could happen, and that's my question. Is that possible? Or in local regulation, is the granting of a permit an inherent requirement?
It's generally speaking an inherent requirement. If they've got a siting regulation in place, then there will be some document that
some
says
approval.
yeah, I mean, I don't know if it's a permit, a special use permit, whatever it may be. It'll be some form of an approval, administrative, generally, et cetera. If that siting regulation carved out a set of wells that don't need permits, then this wouldn't come into play, in my opinion.
Thank you.
Ken, do you have further clarification?
I was just going to follow up on Perry's question. I think Jeff's probably right. It probably wouldn't come into play, but Weld County has siting regulations that say oil and gas drilling is a use by right in most of the ag portions of the county, which means you don't need to get a permit. So that would be an example of a siting regulation without an accompanying permit.
Any further questions or clarification on? So just to be clear, number 12 in the original packet would drop. What was handed out was a replacement for 12A.
That's correct, Sarah.
I have a question on that. My recollection of 12 was that it was directing the Colorado legislature to look at a dispute resolution board. And it's far different than mediation, because the dispute resolution board, as I recall it, was looking at being non-binding, providing non-binding arbitration rather than mediation. So is that going to be scuttled entirely?
Well, here's my view, and maybe I should have been a little more tactical in terms of the conditions under which 12 gets withdrawn. But I think, like all of us, I'm trying to cut to the chase and figure out where we can reach agreement and what the really important principles are. Matt, my ultimate view is that we are re-siphoning a lot of authority back into the COGCC. I had originally intended that dispute resolution panel to be a standalone and to provide sort of an impartial alternative to dispute resolution within the COGCC. I agree with you that mediation does not serve that purpose. I also hope that some version of 9 will survive that clarifies that the COGCC does have a role as an impartial administrator of oil and gas operations in the state. And to that end, it seems to me, and by the way, I've said all along, and I want to restate that through the course of this 5-month short course in what's happening in oil and gas around the state, I have been extraordinarily impressed by Matt and by the way that he has handled himself here. I have no reason to cast aspersions at the commission. So I want that very clear at the outset. However, what I also know, coming from a court perspective, is that impartiality counts, and it's both the certainty of impartiality and the perception of impartiality. It's how people see the decision-making process as well as how it operates. So, Matt, my original intent in terms of setting up a separate entity was to address that dichotomy, to take away from the COGCC this sort of conflicting dual role of having to resolve all the disputes and also having to foster the development of oil and gas in the state. So I guess what I would say is that the dispute resolution process on its own, I still think is a good idea. I don't think it has support in this body. But I am hoping that there will be support for some modified role statutorily documented in the way that the COGCC approaches these disputes. So with that caveat, I would say to you that I'm hopeful that 12 will not need to be in this package in the end analysis. I guess, see, this is what comes from having been a judge and not a politician. I guess it's smarter to say that I will probably, or I may, withdraw 12, depending on how this all sorts out.
Okay. Mr. Tour, last question on this one.
Oh, please.
Oh, Sarah, sorry. Mr. Tour and then Ms. Barwinski.
So I have a question for Ken as a follow-up to your concern with this. I guess I did not realize that there were cases where operators would intentionally go forward and essentially drill despite a permit being denied by a local government. And I'm kind of shocked to hear that. I'm curious how often that takes place. And do you really believe that that happens often enough that that is a material problem with this proposal?
Well, since the Town of Frederick decision, which said that local governments may have a permit requirement and it may take longer than the state takes to do that, I advise clients as a general matter that you cannot proceed without your local permit. But I have had one case in my 31 years of practicing, and it was fairly important to my client. They had timelines. They were about to engage on the construction of a $200 million pipeline through national forest lands, and there were timelines. And this particular situation involved a large water management pit, not a well. But we seriously looked at the possibility of proceeding on the basis of the state permit, given that the county had taken, at that point, I think 12 months and was getting no closer to making a decision. So at some point, that's an option. It's an arrow in the quiver that rarely ever gets fired. But I'll oppose 12A because as an attorney, I want that arrow in the quiver.
Ms. Barwinski.
I wanted to give direct feedback to Becky that I think 12A is simple wisdom and that you fell on that side. I think that as in all of the proposals, there will be reworkings if there's issues. And I would hate to, on the basis of one kind of outlier case, to throw that out. I want you to keep 12 in, and I support your hope that maybe you'll come to the point where you want to withdraw it. All of our goal, I think, is consensus. But I think also we've done so much good work that will be in the record, that our minority report will include many majority votes and will sort of be on a number of issues, perhaps blueprints for the future in terms of directions to go. And I have found your experience and your wisdom very helpful in sort of sorting out those issues in a dispassionate way. And I would want that to be, I would want to have the opportunity to vote on that if the other proposals don't move forward, even if it's not a consensus proposal.
Okay, we're going to try to start moving a little more quickly through these, as I think we've taken on many of the meatier ones, not all of them, but many of them. And so if there are no further questions on 12 and 12A, and once we get through these sections, we will give an opportunity for those of you who are authors of these to give us some feedback on whether or not you will be entertaining any changes to them, so that we can get a sense as we move into the afternoon where we are in terms of the level of revision and further review that will be needed prior to voting. So yes, well, whenever we get to voting, whether it's today or later this week. For 21B, I believe you had some proposed changes.
Here we go again.
So,
Dan, sorry. I'll turn this over to Matt, but I'll set the stage simply by saying that I received a lot of feedback from people who were concerned about the neighboring surface owner provision in 21B. I think Kent maybe said it the best when he relayed that he was concerned about having a neighboring owner tell him what to do on his land. And I'm sensitive to that. And so this particular version was an effort to address that concern. Matt, do you want to speak to it more broadly?
Yes, and because we're on the record, I guess I'd like to just say that I still agree that neighboring surface owners need to have some standing before the Colorado Gas Conservation Commission. When I was working in Russell George's district in Garfield County many years ago, there were innumerable instances where large landowners would try to find a location that would fit a number of criteria, and some of them were to make sure that they could still provide for their farm or ranch. And sometimes it was also to make sure that a location, an oil and gas location, was as far away from their own home as possible. That often put them at odds with their neighbor, because they would place that oil and gas well in the corner of their property, far away from their own home and right next to their neighbor's home. And sometimes it was even done out of spite because they're long-standing feuds. Frankly, if you are within 1,000 feet of one of these oil and gas facilities, I believe that you should have standing to go before the Colorado Gas Conservation Commission and say, I think that this is wrongly placed, and it's really going to harm my life. It's going to harm my well-being, and it's going to be a nuisance for my family for the rest of our lives. The fact that the Colorado Gas Conservation Commission does not recognize those landowners is a real problem. Having said that, I don't believe that we have the votes to get it through with the neighboring surface owners in there, having talked to a few of you. So we have stricken that, and it now stands as just ensuring that surface owners, where the actual location is going to be, has standing. And it also changes the definition of a relevant local government to be those municipalities that have boundaries within 1,500 feet of a proposed oil and gas location. It's very simple, very modest movement forward on the issue of standing.
Any questions, Jim, on this one?
I have my card.
I'm still thinking. Matt, did you say there's a 1,500-foot piece in here? I'm not seeing that.
Paragraph 6, and we'll go to Mr. Fitzgerald and then we'll take.
I've got a couple of questions. It's intentional that you're using the word neighboring surface owners now rather than adjacent surface owners. I like that, by the way, because a lot of times the adjacent person isn't as affected as somebody who might be a little further away. Pipelines, roads, all sorts of things happen. But
I appreciate the feedback, although it is stricken. We were looking at both adjacent and neighboring and felt that neighboring within 1,000 feet around what is called Colorado, what the COGC calls a buffer zone, would be the easiest to administer. However, because of the concerns that I heard earlier, we've decided to strike that. Although,
okay, so
Kent's got some comments.
Pardon?
Unless Kent's got some comments.
I understand what you're doing and why you changed it, but I just feel like all you're trying to do is give someone who lives around there the ability to go to the COGCC and say their case, or your original proposal was saying that. And I don't know how we go back and tell people after all this that those people who are often most affected, I mean, they don't have the right to stop or hold up anything. They just want the right to go to the COGCC and tell their story. And what we're coming out with is something that's been changed so much that we're not giving them anything real, I'm afraid.
Okay, we've got quite a few cards up on this one, Mr. Wansel, and we'll start with you.
Matt, what are the limitations in Rule 503B7 that are being eliminated here?
I'll have to look that up. There's some initial standing requirements, Ken, that the landowner, to have standing to request a hearing before the Colorado Gas Conservation Commission, needed to allege that there was a rule violation. And I think that's about it. I can pull it up though for you.
I just want to be clear on it.
Okay, Becky, go ahead.
Go too much further. May I answer, Jim? Yeah. Jim, like you, I am concerned about sort of the broader group of people who are impacted. What I am banking on is that within the local government consultation process that we are embracing, both in 17 and in 20, that there are duties and opportunities to bring the surface owners and the adjacent surface owners into the process, and that those people have a better shot before their own planning department in being heard than they even would probably at the state level. The thing that actually convinced me that we should pull this was not just an effort to try to gather votes, but rather the notion that if anybody can request a hearing before the COGCC, that we may be buying into a very inefficient kind of bollocksed up process where there are 100 different people requesting a hearing. So I think if we were to go this direction, certainly notice. I am absolutely resolute on the notion of notice and at the earliest point in time. But if we were to walk this path of permitting standing to request a hearing, I think in the interests of fairness, we would have to be really clear as to the basis for which that hearing could be requested, so that we don't just layer upon the COGCC process a demand for many, many, many more hearings that may ultimately not result in a better outcome. So my hope is that both in Pat's and in Bernie's proposals, where the large body of people are impacted, that the notice to surface owners, the notice to adjacent surface owners, and the inclusion within the local government process is some measure of addressing the volumes of public comment that we heard.
John Colton Dubois.
I'm going to hold my question.
Okay, Sarah Barwinski.
One of the things that I think I have learned the most that I didn't truly appreciate in this process was sometimes the unjust impacts on surface owners. So I thank you for that kind of conversation. And so ultimately, I will support this. I am very sad about it being stricken from the adjacent because, in my experience, part of the impetus why people want this is because of decades of abuse for that surface owner that didn't have mineral rights. I think now we're in a new day. I think where we're going, most of those properties with multiple well sites, with taking up so much real estate with such harsh impacts, most surface owners are not, they're going to be bought out. That's what we're seeing. They're bought out, or they own it, or they own the company, or it's owned by the operator. That's where the future is going. And I think this addresses the injustices of the past. And I think that's still occurring. And so I will support that. But I am so sad because I understand where Kent would be coming from. I wouldn't want my neighbor to be able to tell me what to do. But I think the new day, not the past day, the new day is people who are locating it as far away from as possible from their property. They're not going to want to need a hearing. It is their neighbor that might not live in an urban mitigation zone. That might be another farmer, maybe a farmer without their mineral rights, that ends up with the impacts on their land and no redress. So I think this does address a problem, a long-standing problem, and I'm glad that you did it. But I think as we try to stay up with what the current realities are and the current impacts on people, it was far stronger before you struck those.
Kent Pepler.
Well, I appreciate the effort by Ms. Corliss and Mr. Sura to try to appease some of the worries. And I don't know exactly where to go with it, and that's why I don't comment a lot when I'm on this committee. We have to remember that, you know, as we talk about handing the authority over to the local governments, that we're handing them a right, but we're also handing them a terrible amount of responsibility. And historically, a lot of these communities don't have the money. As Jim brought out, it's like, where in the heck's the money going to come? These communities don't have the money, they don't have the experience, and they don't have the expertise to administrate some of the power, really, that we're talking about giving to the local governments. And I don't mean just Little Mead, Colorado. I mean, you can go up the line on the different sides of the different sizes of the communities, or the cities mainly, that I think we're talking about. As far as this proposal is concerned, and historically, particularly with the smaller communities, but also with some of the larger communities that are in along the Front Range. You know, we've seen some pretty serious mistakes over the years with domestic water development, with sewer development, with certainly a lot of land use and housing and commercial development. And so I guess I'm cautious before I hand out or before I support local authority. On this particular recommendation, I'm in full agreement with providing notice to surface owners and neighboring surface owners. And I think, and Steve, you'll have to help me out, but I think in Weld County that's done anyway. I think everybody gets notice. You can request a rule with the, you can request a meeting with the operator, I believe, if you're an adjacent landowner. And, you know, there are many of us that choose not to be annexed to a city or a town for certain reasons, or for many reasons, and one of them is the property rights issues. And to cut to the chase, it's, you know, my family was there. We're the ones that joined the REA first to put the electric lines up. You know, we're the ones that sat on the school boards that made the community what it is today that everybody wants to move to. You know, it's my family that got up at 4 in the morning to make sure that every drop of water was used so that people could enjoy the agriculture view that they have today. So when somebody moves in for 4 or 5 or even 7 or 10 years and wants to tell me what to do with my side of the fence, it gets under my skin a little bit within the community. And that's all I have to say.
So we will go on then to Dan Kelly.
Thank you, Dan Kelly. So just to reiterate, we already provide notice up to 1,000 feet. So I'm just checking the intention with provision number 2. I guess I don't understand what that's asking for, since there's already notice given on all operations. And then I'm just from a logistical standpoint or a feasibility standpoint, do we really have the commission in place that can hear the number of hearings that might be requested if there's no trigger for a commission hearing? If it's just a surface owner without any harm done to them, I mean, the question is, how does the commission handle that many requests for hearings? So I'm just looking for more context there.
So Dan, from my perspective, a surface owner already can request a hearing within constraints. That's the way that it reads now. Matt told us that they very seldom do. Right. If we remove the constraints to that request, I wouldn't expect a flood of surface owners to be coming forward arguing. But by the same token, if you have surface owners who are really at odds with the operator and who have a beef about how things are being conducted, it does seem to me that it's important to provide a forum for that, whether it is before the commission or that dispute resolution panel that's out there in the sky. But I think there needs to be some way of resolving that dispute short of it going to court for everybody's benefit. So I guess my first answer would be, I don't see this opening the floodgates, but if it were to open the floodgates, that kind of supports the notion that there needs to be a place for it to happen. So I think it kind of cuts both ways, man.
All right, thank you. That's good.
Yeah, she answered that. I'm just going to get to your other point.
Okay.
And your other point was about notice, and you're absolutely right. They do provide notice to those homeowners, more or less, within 1,000 feet. This would also go to landowners, and it would be a little bit greater number of people that would be notified, because it would be if they have a property boundary within that 1,000 feet.
Okay, thank you.
Okay, so Will, you're next. And again, we're going to try to get through these comments. The next Three proposals should not take too much time, and then we will move on. We will take a break for lunch.
I have two suggestions on this one. One is on number 6, where it talks about relevant local government and refers to municipal governments. I would suggest that that be any local government, so that includes counties. And there are certainly cases where there are very significant multi-well production facilities being put up right on the county line, and we've had multiple experiences with this on County Line Road in Boulder County. And so that would be one suggestion. I don't think in principle there's any reason why a municipality should be treated differently than a county. The other one, which is perhaps a larger suggestion, but understanding the concerns that led to you dropping the neighboring surface owners, I wonder if there might be a compromise approach that would retain neighboring surface owners, but only in the case of the large multi-well facilities, so that you wouldn't be opening it up for every facility, but above some threshold where there clearly is a significant impact on people within that 1,000 feet. So we just ask you to think about whether there's some potential amendments.
Okay, Mr. Wanstolin and then Mr. Rao.
So I did look up 503B7, and it's both non-compliance and to allege potential adverse impacts. So if there is a dispute between the surface owner and the oil and gas company outside those areas, that falls under the Reasonable Accommodation Act, which by its express terms provides that those sorts of disputes give rise to a cause of action in court. So there is no jurisdiction of the commission to hear those, and this cannot be accomplished by rulemaking. It would require an amendment to the Reasonable Accommodation Act. That's number one. Number two, on the burden of proof. So as I understand what you're saying is that the plaintiff, if you will, the local government who is complaining about the state permit being issued or approved, what is the nature of the complaint? And there's no obligation to carry forward any sort of proof. You just allege that something's wrong and you have no obligation to make an initial showing that the case should move forward. I'm not sure what you're trying to accomplish.
So I'll answer the first part and then turn it to Matt for the second. To quote previous statements made here today, I completely disagree with you in terms of the commission's power and role in the enforcement of the accommodation doctrine. So I would merely say to you that I've tried to address that from a variety of perspectives, including a potential amendment to the statute or to the rules, but it is my view that it's the commission's fight to some extent as to whether the surface owner and the operator have reached accommodation. And if they, I understand, Ken,
Any
you don't
support in the
agree.
statute for that?
I understand you don't agree. We'll park it right there.
And your other point was to whether or not local government should have standing to request a hearing?
No, I'm asking what's the nature of the complaint, of the allegation, and why would it be that the party making the allegation there's some problem does not have the burden of moving forward with a sufficient case to get the action going? I mean, you're removing any obligation from the local government that can simply allege that the commission's permit results in adverse impacts, and then who goes? The commission, the operator? Who moves the case forward?
Well, we were told, and maybe you weren't at this meeting, but in the initial meeting, that the greatest authority that has been given to local governments by the Colorado Oil and Gas Conservation Commission rules is the ability to request a hearing. That's something that Matt Lepore said. That is the hammer, as it will, that local governments can use to negotiate. That has been diminished, and in fact, industry has, when this has happened in Gunnison County, industry challenged their going forward requesting a hearing on a motion to dismiss, saying that they didn't allege properly, and meet all the criteria that are spelled out in that rule. It is an important tool for local governments, and it should be used by an ability to get a hearing by right. That they request the hearing, they have some concerns about it. Those concerns can be then addressed before the commission.
By who? Which party takes over if the local
I'm
government has no
going to
burden?
cut off a debate on this, I think, and just continue because we're getting more cards up. And I think just want to make sure we're moving forward with the conversation. That's all right with the lawyers in the room. Mr. Rao, did you have, I just want to get further comments up and then we'll.
So
move
my
forward with
comment's shorter and a lot less meaty. In paragraph 2, you're utilizing, and I'm going to take some responsibility for this because I submitted the proposed amendment, but you're referencing neighboring surface owner, and we have in fact stricken any definition of who a neighboring surface owner is. So you may just want to consider bringing a portion of that back for that purpose. Thank you.
Got it. It also shows up in the description, Bruce, which we'll have to clean up.
Okay, Mr. Robbins and Mr. Golden Dubois, you guys have the last comments on this.
I'm a lawyer and I'm not going to speak to this.
Okay, thank you. Mr. Golden Dubois.
I just wanted to state my preference for the previous version. I do think with respect to Kent and to others who are surface owners who have some of this activity on their property, I understand his position and I respect it. I do also think, though, that some of those who are adjacent and who are neighboring surface owners may not experience many of the benefits of oil and gas drilling that a surface owner or mineral owner might have, and yet they oftentimes are forced to manage and deal with and live with the adverse consequences. And I think that recognizing that that is a reality within the current context and ensuring that those adjacent neighbors where there may be heavy development have an interest and have some outlet for expressing their concerns about this at the commission level doesn't guarantee that their issues get dealt with or addressed, but it does at the very least allow those to be heard by the commission. And I think that's a pretty important concept given the burden that they may experience in the development in their neighborhoods and in their communities.
Okay, I think that concludes.
One sentence. One sentence?
One sentence,
One
please, Sarah.
sentence. The surface owner where the wells near my home are located lives in Arizona and has millions and millions of dollars that I do not. And I live 750 feet from the well. So I think your point is well taken. Thank you, John.
Okay, with that, we'll close out the discussion on this proposal. I do want to recognize the folks that have come into the room during the middle of our conversation. Thank you for your patience in allowing us to close that out. My understanding is, we're not taking public comment. You have something you would like to distribute to the task force. Our protocol is to do that through staff. If I can have a staff person come over, please. We will get your materials to this is our staff person, Doug Young, and distribute them to the task force. And thank you for understanding how our process is working today. And ma'am, we aren't taking public comment, but we appreciate that. I'm sure it's on the cover to your letter. All right, with that, and you're welcome to stay. With that, we'll move on to our, we have 2 more proposals that have been, 3 more. But they should be quick. They should be quick. Let's see where we can get. We want to get through the revised proposals and then take a break for lunch. But let's see how discussion goes, and we'll make that call.
So 25, 26, and 10 have all been revised, but less significantly than the ones that we have just been through. And on the whole, at least 2 of them had significant support coming out of the last meeting. So hopefully we don't need too much discussion on them. So if we can get through 25, 26, and 10, we will then take a quick break for lunch. So 25 is Mr. Hawley and Mr. George actually agreed to combine his proposals of similar intent on local government designee programs. Mr. Hawley, anything you want to suggest here? Again, the main changes here were editorial in nature and in combining the previous other proposals that also address a similar issue.
Sure, in an effort to get us, I don't even know if get close to back on schedule, but the effort here, I think both of these received unanimous support at the last meeting. And all we've attempted to do is, Russ and I have combined ours into one document, and you shouldn't see any material changes there.
And again, these cover the support for the local government designee and local government liaison programs. Any questions on this? Are the cards up from previous conversations? Okay. Any questions on this one? Okay, we can move on then to number 26, which is the local government fees. And again, I think, Matt, you just added some explanatory text to this proposal.
That's right. I think it speaks for itself.
Any questions for Matt? Or clarifying statements or questions? We threatened you all into not making any comments. All right. Okay. Number 10, which addresses pooling. This was not a substantial, it was really a clarifying change made to the proposal that we reviewed last time. Mr. Wansteland, do you want to address anything in Mr. Woodall's?
Just to be clear, it doesn't address pooling. It addresses the formation of drilling and spacing units, which is separate from pooling.
Yes, okay, thank you.
And as you may recall, Mr. Woodall was asked on the last occasion here that this would be an optional process. He responded in the affirmative, and this language change is designed to make it quite clear that it's optional.
Okay, thank you. Mr. Sura and then Ms. Corliss.
I agree that these units can be used to create more flexibility, to be able to enable greater planning. Is there a possibility of linking this to one of the planning proposals? My concern is that we've also seen where this proposal, existing ability to create units, can be used in ways that aren't as helpful to the people who are impacted, who are brought into those units against their will and possibly even force pooled ultimately. There's also a concern about these mega units that might be created that would be held by production by one well. And I'd like you to speak to that as well, as to whether or not there needs to be some sort of clarifying language to require development of the resource rather than just putting in the one well and saying that the entire 2,000, 3,000 acres are being held by production.
On the first part of your question, there's a link to 17 and 7. I think the answer is yes, and I think 17 makes an explicit link and lists these types of unconventional resource units as one of the methods that could be employed to resolve the process set up in 17. I think the same would apply in number 7. So yes, I think there's a natural link between 17.7 and these units. As to the latter question, that's a separate question. I would say that every one of these units that has been established to date by the commission has a requirement for a development plan and an annual report back to the commission on the progress towards meeting that development plan. I think the commissioners are quite aware of that issue that you bring up and have addressed it through conditions of approval on every one of these. And I would anticipate that all the mineral owners in these units who all have standing would ask for that sort of condition of approval whenever these are established.
Would you consider putting that, rather than having it be a condition of approval that has to be put on every one of these permits or units, have that be something that is in your proposal?
No, Mr. Woodall got 21 green cards on this, and he's not inclined to make any amendments.
Okay, Ms. Corliss.
So I have some concerns about this, and they relate to what Sarah mentioned before, which is what I'll call, in the vernacular, sort of the push-down pop-up problem, that by moving a site away from a residential area, that there may be some unwitting sacrifice zones of agricultural lands or other properties that are perceived generally to have less surface impact or less damage. My concern about this, Ken, is that I do think if there is a forced pooling process, that there will be surface owners implicated and perhaps subject to a burden that they would not otherwise be subject to. I went through 3460-106 and nowhere does it mention notice to the surface owners, nothing. The pooling process can proceed without including any of the involved surface owners at all. And I just have to raise a red flag that concerns me. I see this as a very legitimate management tool, and I think it's the direction in which we should move, but not by identifying a group of people who then will be subject to all of the impact without any corollary rights.
You're correct. The pooling process does not entail notice to surface owners because severed surface owners, if the surface owner is a mineral owner, of course, they get that notice. But that's because they don't have a property interest at stake under the ground. But the well siting that follows thereafter, of course, involves notice to the surface owners. And you go through the same notice consultation process that you do for any well site. So there's no change whatsoever in the commission's procedures for permitting a well location or production facilities by virtue of this. It makes no change whatsoever.
I beg to differ because you're talking about the potential of these mega sites being authorized, being facilitated by creating these large units, and then suddenly, rather than having, if there's a landowner that has no minerals, rather than having them expect that they're going to have 1 or 2 wells, suddenly they may have 30, 40 wells, 50 tanks, and because they're part of a unit, they've got absolutely nothing to say about it. They can try to negotiate with the industry, but ultimately the industry has a trump card.
The surface owner for any well site, no matter how many wells, has a right to a hearing in front of the commission. So to say they have no say about it is totally wrong.
Okay, and I'm going to, again, just remind us that we're asking clarifying questions about proposals, seeing if amendments should be offered or may be accepted. So just remind folks to keep that in mind with the back and forth, recognizing there isn't complete consensus or agreement on many of these proposals. Mr. Rao, you're up next.
I'm just going to echo a lot of Becky's comments and try to avoid repeating them. But I do think it's worth noting that our votes last time around, of which I was one of the supporting votes, support the idea of this concept moving forward. And I concur that it is an important concept to try to get at the best available location for the surface use by the operator. Having said that, surface owners will be impacted by that. And I think that it's critical that there is a mechanism for addressing the change in their circumstance as it relates to those impacts. And to the extent that the surface owners' proposals move forward, I think that's sufficient. To the extent that they don't, I think it's critical that this be amended to address that.
Perry, and then Jeff, and then Tara, and then we'll try to break for lunch.
Thank you. This is Perry Pierce. Couple of comments. I want to remind you again, not to be too pointed. Having served on the Oil Conservation Commission and having gone through a lot of hearings, I can assure you that Mr. Juan Stolen and Mr. Robbins and Mr. Sura will participate in handling this recommendation that the COGCC consider something that will in my experience, be a long, complicated, hotly contested hearing. And I think we are down in discussion of conflicting opinions now that are better left to the COGCC. It's a recommendation that the COGC consider this as 10 is written now. I think that's what we ought to consider it to be. Thank you.
Mr. Robbins and then Ms. Berensky.
Briefly, I agree with Bruce and Becky and Matt that this needs to be brought into 17 or one of the other planning processes.
Thank you. Ms. Berensky.
I was just hoping that might be a consideration, that if 17 passed, it would be withdrawn. I think it's an incredibly important citing tool, which is what 17 deals with in terms of the COGCC rulemaking, to work out those kind of conflicts.
Thank you all very much. Any other further comments on number 10? If not, we'll take a quick break. I would suggest before we take the rest of the proposals in this, we'll move to the health proposals. I know Dr. Walk is with us, and it would be nice to take advantage of his time.
Well, that was my point, because Dr. Welk has to leave at 1:30, and we need to respect his time.
So we'll take if we can take just a 20-minute break for lunch so that you can all come back to the table without having to talk with your mouths full. We'll pick up on the proposals 27 and 34. It's actually 31B after lunch.
Oh, I'm over. Your boobs?
briefly skip over those proposals that remained unchanged from our last meeting on pages 2 and 3 of the chart. And we're going to move on to numbers 27, 31B, and 34B for consideration. Just simply, we have Dr. Walk here from CDPHE and want to both take advantage of his time and not keep him here endlessly while we move forward. So,
but excuse me, before we get started, since I'm 27, I wanted to call a point of order with our co-chairs. One of the recommendations I'd like to make for the task force to consider is, since this is taking much more lengthier time, which is justified for people to ask questions in terms of the different recommendations. I know that the agenda, we're supposed to end around 5 o'clock. I would really like if people could stay, and if they're okay with that, if they can stay after that hour to try to get done as much as possible tonight, and maybe extend that time.
Okay.
I, for one, want to support that, and I would love to see the task force as a whole move to a vote on all of the items that are before us today.
Great.
I'm going to, is a motion in order?
Motion in order?
No, I don't think so. We get, we'll see what.
Yeah, let's wait.
Let's wait. I think we will go a lot faster shortly with the non-revisions, but there was a lot of substance to the proposals we need to discuss. Let's just do a time check at some point and see where people are.
From here on out, the changes to the proposals that we're going to be discussing are far less significant than the ones that were underway earlier today. So we will move it along more quickly. And again, a reminder to you all to help us keep on track. At this point, we'd like to keep debate on opinions about the proposals to a minimum, but really offer either support or things that minor changes that may help you further support a proposal going forward if the author is willing to consider amendments. So what we'll do is we'll move through the staffing and health proposals. We'll come back to the land use proposals. Again, for those of you who are authors, we'll need to know at that point whether or not you're contemplating any amendments, and then we'll go. I think we'll have a better sense of the time needed as we do that.
Okay.
So with that, let's move on to number 27. Which again was a combination of several proposals that were made. Elbra, it looks like you're going to walk us through this.
Yes, thank you. Elbra Wedgeworth. I'd like to speak to number 27, which is a combination with 29. I'd like to thank Russ and Harry and Rebecca for their assistance and support in this. This is related to the COGCC staff recommendation, which would include field inspectors, regarding operations, enforcement, and permitting staff. As we heard, excuse me, through our public process and from Mr. Lepore, there was and is still a need in terms of being responsible for conducting intakes and environmental investigations and so forth. And mainly what we were hearing through this whole process the last 5 months is citizens' complaints and how you process permit applications and those, and also collecting data. Because I'm sure through this process, we're going to even get more data. And to put that on a department without any type of support, I think is not being very responsible. So we had talked about initially having 22 full-time FTE, but then to really look at the numbers in terms of what's being required and knowing the environment of the industry right now, want to take another second look at that. So I basically want this reduced it to half, but then, the final recommendation is to make it to 12, from 22 to 12. So in terms of field inspectors, instead of 6, it would be 3. Environmental unit, which would be environmental protection specialist, from 6 to 3. Engineering unit from 5 to 3. Hearings unit, from 3 to 2. One would be for complaint intake, and the other would be for a hearing officer. At this time, it's not as concerning to have anyone else added to the permitting unit, so we've taken that off the table. And then have an information tech, which would be a junior data specialist or analyst. So that adds up to the 12 staff. And so I really feel that this is important to pass on to the governor and the legislature to give them the tools that they need to do their job properly and to address a lot of the complaints that we were hearing or concerns throughout our whole process. And so if, Mr. Lepore, if you want to, you're eating, so you want, you all right? Okay. If you want to add anything else to this, please come forward, please.
No, thank you for putting forward and
Okay. So again, thanks to Russ and Perry and Becky for being supportive of this proposal.
Any questions, comments? Okay, if not, we'll move on to 31B, which again was one that combined several different proposals related to health studies and health monitoring. Albert, are you going to walk us through that one as well?
Yes, thank you. This is a recommendation for CDPHE for also staffing for the health complaint line, human health risk assessment, and mobile and air quality units. Again, we heard through our public process that people were very concerned in terms of these issues and how we could properly address them. And so in talking to Dr. Wook, I'd like to also thank Dan for helping to consolidate all of these proposals along with Bernie to convert the 5 temporary FTAs to permanent status so the department can continue its air monitoring and leak detecting activities. To also address the health complaint information line. And we're urging the General Assembly to consider providing support for the mobile air quality monitoring unit and associated staffing. And finally, also that CDPHE seek funding from the General Assembly to conduct a human health risk assessment. We feel that all these tools will benefit our people of Colorado and that it will address a lot of the complaints or concerns that we heard during our whole process. So I appreciate everyone being willing to consolidate these different recommendations. And again, thanks to Dan and to Bernie.
Any questions, comments, concerns regarding 31B?
The one thing I wanted to do too, since Dr. Welk is here with your approval, co-chairs, is related to the methane rule because that does come through CDPHE and that is number 49. There was a recommendation for an additional amendment to that. I believe that came from Randy Cleveland. And since Randy's not here, no offense, Lisa, but I'm going to reject that recommendation because I feel when Randy, he was a neutral vote on that methane rule to have it move forward. And so I feel that there is support without the amendment from Randy, there's support enough for that amendment. So just tell Randy, no offense, but I'd like to have it move forward as is. Thanks. And I don't know whether Dr. Welk wants to address the methane rule or not. You're fine? Okay, you good? Okay.
And this is one of the more timely ones since the rules bill is up for a vote any moment now. So any discussion on 49 since Ms. Wedgeworth brought that to our attention? We'll take that off the list. Okay, any further discussion on 31B? If not, we'll move, since it's related to this, to 34B, and then we'll come back to the land use one. Mr. Fitzgerald.
The 34B is something, it's a proposal that I take very seriously. I think it is in an effort to try to assure the public that that every effort's being made to measure the danger that public health that might come out of the drilling and the fracking. I just found a nice little quote from Russell George at the bottom of his one of his proposals is that ordinary people are entitled to know if their health is at risk, and they are also entitled to know that their health is not at risk. Knowledge is the best tool to prevent fear and fear-mongering. I think that what happens whenever there's great change to people, to their homes, to their neighborhoods, to where they live, there's two words I think of. One is uncertainty, and the other is fear. And it's crucial to try to do everything that we can to make people feel at least that what's happening is transparent. I support, of course, the recommendations for the health studies that's in the other proposals. What I think is important is someone look now at what we should be doing, or as soon as possible, so that we don't walk out and people say to us, oh, our health might be in danger, but you're going to go on studying it for years and years and years, and nothing's going to happen. If you think of the federal legislation or NEPA, when a new change, something that has a significant impact on social or environmental issues, they have to do an environmental assessment or an EIS before that starts. I think it's high time that we have some kind of confirmation that this seems to be all right to continue. So my proposal suggests not new research. I think that's adequately covered, and I simply want to take what's available right now and have people, have CDPHE review that. I'm sorry, I want them to administer it. I'm asking for an independent organization that is a research organization, which CDPHE is not a research, they're a regulatory, but contract with an independent organization. There's got to be trust in what these people say, and have them spend 3 months looking at existing literature studies, both in Colorado or out of Colorado if they think that's relevant. Put it together and then either assure the public that it's all right to go on as we're doing right now, or if they can't assure that public until a health assessment, a comprehensive health assessment is done, that they then stop the drilling and the fracking until we can make that assurance. I think that the industry owes that to public. I think it's something people desperately need. And I think that this public health, just as a practical method for getting a hold of it and saying, yeah, we think this is okay right now, or no, we don't think it's okay right now. That seems the least that people could expect from us. I have talked with researchers for public health about this and have gotten very strong agreement that they feel that something like this is definitely necessary. I could read you quotes. Becky doesn't like quotes, so I better not. From some of these studies and some of the things people have said who have started doing the studies in Colorado, both CU and CSU. And they're very, very strong. We don't have data. We don't really know what we're doing in terms of health right now. People are sincerely trying to get a hold of it. But I think there ought to be a period, a stop, where a document comes out that says, this is what we know right now, and this is what our best judgment is in the future. Thank you. I'll take any questions.
Any questions or discussion on 34B? Okay. All right. What I would suggest now is we move back to the land use section then, and take up the proposals that come next in your packet that had no changes between the last meeting and this meeting. So that would start with number 2, I believe, which is Mr. Robbins.
Thank you. This proposal has not changed. I didn't have anyone have any questions about it, nor did people make inquiry about changing it. The proposal is meant to address one of the things from the executive order, which told us to explore methods to harmonize state and local relationship. The proposal is also meant to address the events on the ground that I think has brought this task force together. I think there's a need to clarify and elevate local authority to allow local governments better ability to influence what's going on the ground and mitigate the surface and land use impacts of these large operations. I think this proposal, if adopted, would allow the state to implement a rule that establishes that local surface and land use regulations can be stricter than similar state surface and land use regulations, provided there's not an operational conflict. So with the proposal, I'm leaving in place the sidebars that industry is used to. That is the application of the current preemption standard. I believe this proposal somewhat comports with current law of local governments, in that as long as the use of their own regulations is not in operational conflict with state regulations, it ought to be considered valid. But I think having the state recognize that in a rule would go a long way toward allowing those local governments that have pivoted to moratoriums and bans to instead get smart about how they enact local regulations to try to temper the surface and land use impacts of oil and gas. The other component to the proposal is it seeks to have the COGCC enact a rule to harmonize implementation of its regs with local regulations where possible. I think that it's fairly self-explanatory in terms of, again, trying to meet the tenets of the executive order to establish a better understanding and harmonization of state and local authority over oil and gas operations.
Any questions or discussions on number 2? Mr. Busher.
Thank you, Sarah. Jeff, I think I've read and reread this more than any of the ones in this packet, except for my own.
I take that as a compliment.
I guess at the end of the day, my question for you is just simply this. Does this change anything?
In my opinion, no, I don't think it changes anything. I have counseled local governments that their authority in land use and surface impact authority can be stricter than state authority in a similar arena. However, they can use that authority in a manner that creates an operational conflict, and they get checked back, and that authority needs to be circumscribed. So this is not trying to change that authority at all. It's not trying to change the current operational conflict test that puts sidebars on local authority. It really is establishing at the state commission an understanding and an acceptance of that dynamic and that authority, which I think will assist communities to try to use their authority in a manner so that they don't end up with citizens pivoting toward more egregious forms of authority.
And if I could follow up, because I tend to agree with you that this doesn't change the law. Could you tell me what you believe the effect of COGCC doing something and why you made this a regulatory matter rather than a statutory matter?
There have been attempts to look at this from a statutory perspective. Frankly, I felt like we had a better opportunity to achieve a small success through the regulatory agency than through the Colorado legislature at this juncture. And since this is not changing, that authority at this point, I think it's something that the COGCC could implement.
And again, just a reminder, we're asking for clarifying questions and discussion on this. We have Pat, and then Ken, Sarah, and Will.
And when do we have the discussion on the merits of each one of these subjects, if there's just clarifying questions?
You can offer merits, we just don't want to get into a large debate at this point.
I think if there's going to be a debate, this is the one we should have a debate on.
Okay.
Okay, I mean, you've been saying the whole time, let's not have debates, and this is the issue that we should be debating. is what degree of local control is. So, I mean, I guess I'm just gonna make, I mean, there've been so many constraints. My biggest issue here is that, I think of the presentations we've had, the legal presentations we had in Durango were the weakest that we've received. And so I'm not a lawyer. You know, I got pulled into this. I'm an accountant. And I got pulled in this because Broomfield got brought into this huge battle, you know, that, you know, with national people coming in and, you know, and the stuff. So I guess I want to understand too. And I want the right to discuss too. Because I've heard from the industry, they don't like it. They don't support it. I've heard from all the other people that they think it's absolutely paramount that we pass it. And I don't understand, because as I said to several people yesterday, I don't understand what imposing stricter standards and where that's going to occur. I understand why the industry would be afraid of that. I mean, 64 different counties, and if municipalities get forward to it, I'm trying to get a flavor for what this rule truly means, what a real world example is of it. I mean, and I want to know why the industry, you know, is opposed to that. I guess my best example comes down to that I was talking yesterday is that obviously in Broomfield or any city that chooses to update its comprehensive plan and look at it, there's going to be areas where there's going to be disagreement, where the industry is not going to like, you know, the industry is not going to like where we want to move them to. And my question because, you know, my compromise has not been easy, you know, to achieve. I'm curious what then happens and what rules the COGCC follows if they're trying to resolve a dispute. I mean, because I think it's likely there'll be a dispute on location. I guarantee it's likely that the operator may not like it, and mediation may not solve anything at that point in time. And we're at the Colorado Oil and Gas Commission, and I presume that's where this rule comes into play. I mean, so you now have Broomfield or some city that sit down saying, we don't like the location of this because we think if you skid the rig 1,000 feet over, you know, which you can do without an operational conflict, it's going to reduce a lot of political issues within Broomfield. It'll fit with it because the Sovereign well was going to go into commercial retail or neighborhood retail. And I mean, I can guarantee you a drilling rig doesn't belong in neighborhood retail. So if I read your rule correctly, you're saying that then the neighborhood retail out of the comp plan would prevail. And I can understand that may be a problem to industry. I mean, so if the COGCC, and I put this to industry as much as anybody else, if they're going to resolve these disputes, what rules do they look at? What are they going to look at? And Jeff, and that's where I'm trying to get a feeling. I mean, your rule, I understand it, but I don't understand what the sideboards, other than operational conflict, which is a legal term, that means more to you and the industry members than it does to me. But what rules are the COGCC going to look at when they're doing these disputes between local governments? And I presume that's what you're getting at here.
Well, I'm trying to be more simple than that, frankly.
What was your simple quote?
Yeah. Because, you know, there are different approaches to regulating at the local level, depending upon the community. They're not 64 different approaches because many local governments, and we've heard from many of them, more than a majority, don't actually regulate, and they don't want to. But for those communities that do want to regulate, we need to be addressing that core issue to give them a relief valve so that they can do a good job, so that we don't have the things that led to this commission. So, you know, for instance, at this point, the commission has some pretty minimal rules concerning visual mitigation.
Right.
They've got some minimal rules concerning aesthetics and, you know, how it looks. They've got some rules concerning, you know, noise associated with that, and municipalities have authority to regulate noise, and that's kind of a surface sort of thing. You know, there are rules, so local governments get involved in that same arena. And I can tell you that in the past, I've been approached by industry lawyers that say, well, you know, wait a minute, you know, you can't impose a rule or apply a standard that's stricter than one of these state rules because you're preempted. And all I'm trying to do is say, no, with regard to the surface and land use components of oil and gas operations, the state ought to acknowledge that locals can have an ability to go further, provided they're not materially impeding the state's goals of the operational conflict test. That's all this is trying to do. And let me point out too, and I meant to make this in my opening rant to Steve, this is discretionary. Well County does not have to use this. They can take it and they can rip it up and throw it away. So I just want you to be aware that this is not mandated to local governments that you have to have stricter than state rules. Absolutely not. It's for local governments that desire that they can. again, with the sidebars that I've talked about.
Pat, did that answer some of your questions? And again, Ken has his card up. I think, Pat, you had an invitation to hear why this may be objectionable to some as well. So,
Well, you know, I mean, noise is a great example because it's been in the paper lately, so if I mean, I can understand though, once again, why the industry, I mean, there needs to be some adoption of some standards. And you're saying the operational conflict covers that. I mean, that term operational conflict, at some point in time, the local community goes up against that rule.
Right, right.
And there's no standard rule across the state though, as to when operational conflict occurs.
There's no rule across the state, no. In fact, there is a rule in the state commission's rules right now that says if the local has an operationally conflicting permit, then it's deemed invalid as against this rule. So it's already in their rules. So, but the point being is that, well, let's hear from industry and then we can try to help flesh that out.
and I don't know if that's why you raised your card, but to the extent you can address any of those
It
questions.
is.
that'd be great.
It's interesting, Jeff, that you use visual mitigation as the example because in town of Frederick, of course, the court struck down the town's visual mitigation rules on their face without going back for the development of our record. And it won't surprise you to learn the industry disagrees entirely with Mr. Robbins that this is not affecting a significant change in the existing law. And I'll just give you one quote from the Bowen Edwards case, which is one of the two seminal cases.
Can you speak up a little bit?
Yes. In Bowen Edwards, the court said, and I'll quote here, the court hastened to add that there may be instances where the county's regulatory scheme conflicts in operations with the state statutory or regulatory scheme. For example, so the example the court gave, the operational effect of the county regulations might be to impose technical conditions on the drilling and pumping of wells under circumstances where no such conditions are imposed by the state. So the example the court used was where the state did not have any regulation and the local government put something on, and the court said that was an example of operational conflict. I think in my career working these issues, local government attorneys reject that reading, and they like to go back to this more amorphous material impairment standard, which was argued in the recent Longmont case by Longmont's counsel, that preemption does not protect the right to make a profit. So the argument was, well, Longmont's banning fracking, but you could use underbalanced drilling and you can get the resource, you just won't get enough to make any money, which sounds a lot like the president saying you can build a coal plant, but you're going to go bankrupt if you do it. That's not a standard that industry feels comfortable with. So this does, by the plain words of the existing law, affect a major change, and obviously industry would be opposed.
If I could respond.
Yeah. Go ahead, Jeff.
Yeah. No, I appreciate that, Ken, and you and I have had a healthy disagreement over this for a long time. I would inform the task force that, yeah, that is industry's perspective, and so maybe this doesn't do much, given what their position is relative to what the authority is of local governments. I would also, point out that in another proposal that's that has garnered huge support by this entire task force, the concept of whether local governments have authority is even at play. That proposal, it has a savings clause for local governments. It says whatever local government authority locals may have. So we have obviously, and I think that goes to the core of this whole reason we're here, is we've got a tremendous discord between what industry would like the states to understand to be local authority versus what locals are trying to understand as their authority. This is not, as Ken just pointed out, this is not asking for a lot. He even suggests that this is illegal on its face. I don't believe that to be the case. So I would encourage folks to think through whether this is a good step toward trying to accomplish some of the goals of the executive order.
I agree that this is a very modest attempt to try to do what we've been asked to do, to provide even an incremental step in clarity on this. And so you could argue, oh, it does something or it doesn't anything, about how it how does it affect somebody on the ground? So when I came to to try to make sense of what was happening to me and to my community, I assumed that the laws on the books in terms of my comprehensive plan, in terms of their development code, had some meaning. And I was disturbed that the arguments that we made from those plans seemed to be so dismissed. So disturbed, I took whatever avenue I could. I went to COGCC, I've had conversations with Matt Lepore, I went to the governor's office. And oftentimes what I would hear from the state is, well, you know what, Greeley has more power than they are using, and so you should argue with them. And then I would go to Greeley and I would say, hey, I'm told that you could make a difference here, and I'm arguing from your code. And then I'm told, well, no, because of Lundvall versus Voss, and no, they've already approved the permit, so you have nothing to say about anything. So at a planning commission hearing where we really did a bang-up job arguing from our own development code about a plan that many of your people, engineers in your operation, said, we'd never drill here. Responsible engineers saying, we'd never drill here. The industry lawyer stood up and said, you know, those are fine arguments, but they don't mean anything because of preemption, operational conflict, Lundvall versus Voss, name on and on. That intimidation, that interpretation made all the difference in the world in terms of a local government exercising even the power that they do have, let alone the argument that's been trying to be made about expanding it. So I think this is the most modest baby step that we could take, and I acknowledge that industry isn't going to necessarily agree. I hope some industry partners will, but I'm really appealing to everyone here that if we're going to be successful, that I would encourage you to vote for this. And it does make a difference on the ground, not because it changes the law, but it changes the clarity about the law and is a message to local governments that, no, you don't have to ban. Greeley's not about to ban. Greeley's not about to do any of that. They're just saying, this one site, what can we do about it? Thank you.
Will Tour.
Thanks. So I strongly support this recommendation, and I think it's one of a handful of recommendations that are important to move forward in order for us to really make progress on the core mission of the task force. And I think that harmonizing local and state authority is really part of that core mission. I've had some experience as a local government representative addressing precisely this issue. And I think I tend to agree with Jeff's analysis that I don't think that this really expands local authority, but it helps to clarify the authority that exists. And I went through a year-long process of adopting oil and gas regulations. During that process, literally, I believe this is accurate, may not be totally accurate. I was going to say literally every element that we brought forward, industry lawyers testified that we were preempted and did not have the authority to move on each individual element. There may be one or two minor ones where that are an exception, but certainly every major element of the regulations. We were a pretty sophisticated and well-funded local government that were able to afford significant outside counsel and ultimately concluded that we really did not believe the arguments that were being made by the industry attorneys, and ultimately adopted a rule that has never been challenged. But having additional authority in that process, I think would have made the process, additional clarity would have made the process go much more smoothly. In addition, after I left that jurisdiction, the jurisdiction ended up adopting a long-term moratorium. I believe that part of the political calculus that goes on there is a sense that, you know what, we adopt reasonable rules and they're likely to be challenged in court, and we don't know we really don't know ultimately where what the state is going to argue in terms of authority. You know, if we're going to be sued, we might as well be sued for something which really reflects what our citizens want. I think that if there was clear authority to be able to adopt reasonable rules and you didn't think you were going to get challenged, it would make it much more likely that local governments in the places where this is really contentious would go with those reasonable rules as opposed to long-term moratoria or bans. So I think ultimately this would be in the interests of industry.
Thank you. We have Matt, Sarah, Bernie Busher, John Golden Dubois, and then Brad Holly.
I brought this up in one of our small groups a month ago, so forgive me for my small group participants that heard this before, but I'm currently representing municipal government trying to write some new oil and gas regulations. The issue that you're asking for an example that readily comes to mind. Knowing that the Frederick case was out there, Ken, I look to other municipalities. What are other municipalities doing that haven't received any challenge? On this visual mitigation, I found the Greeley regulations were actually quite good in many respects, requiring some landscaping around some of these oil and gas facilities. I borrowed part of that, not all of it, because they go far beyond, you know, what the local government was hoping to do in our jurisdiction. Colorado Oil and Gas Association attorneys said, this is preempted, and cited Frederick. I said, wait a minute, this exact language comes from the city of Greeley. And they're not saying no to any oil and gas development. In fact, they're embracing it. But Greeley wants to be beautiful and doesn't want to have industrial facilities that look like industrial facilities in the middle of their parks and in their neighborhoods. And they've come to, you know, and no one has challenged them. And COGA has stated point blank, just because we haven't sued Greeley doesn't mean it's legal. Really? Really? Is that how we want to proceed? I mean, what Greeley is doing is really reasonable. That should be right in their wheelhouse of local authority to try to make sure that their constituents aren't looking at an industrial facility, that it has some trees around it. And really, the industry is going to say that that's preempted? I think that this is absolutely essential that we pass this today.
Bernie Busher.
Thank you, Sarah. Two questions, Jeff. One, who determines whether or not there is an operational conflict? Is that a matter only for the courts to determine? And if so, I go back to the question of how do you do a regulatory matter that determines that level of law? And secondly, could you just talk about the areas in which this argument about operational conflict occurs? I think I've heard dust, sound, visual mitigation, truck traffic, and maybe one or two others. But I want to make sure I'm understanding the areas that we're talking about, because when we talk about it in concept that locals can do something more than a state rule, I'm worried that I may be missing how this is applied in fact. Can you help me with those?
Yeah, well, I think to answer the second question first is just to look to those areas of state rules that impinge upon land use or surface use. And, you know, I've had this discussion with other lawyers. Sometimes it's hard to determine, you know, what is a, you know, technical versus what is a land use. But if you look at those areas that are sort of the traditional local government land use tools, the things that you articulated, you know, as well as aesthetics and visual and, you know, noise, you know, the things that impact people on the ground, the things that people that have come up and testified to us for 5 months that have caused them to lose sleep at night. Those are the sort of things that I think a local government has and should be able to apply regulations against, provided it's not, materially impeding, the state's goals, using that standard. And I just, I'm not trying to, in this suggestion, I'm not trying to alter or edit that standard.
And the question about jurisdiction?
I think that I'm not trying to alter that either. I think that, when you have two buckets of authority and when you have two permitting processes, a local government can't override the state permit, and the state shouldn't be able to override the local permit. And if the operator feels like they've got inconsistent permits, they go to the district court for an independent, neutral, judge-made determination of whether, in general, whether the local government permit is invalid. I've not seen the situation where anyone is trying to invalidate the state permit.
So does everyone agree that the courts determine whether there's an operational conflict, or is that a matter of jurisdiction also for COGCC?
I'm sorry, say that again.
If there's an argument about whether or not something has been preempted because of operational conflict, is that a matter that would be subject to determination by the COGCC, or is it only a matter to be determined by the courts?
Well,
I don't know. I'm just trying to think this through.
No, I mean, the COGCC routinely issues permits that are inconsistent with a issue, or not routinely, but it happens, where there is an inconsistent permit issued by the state and the local government. What can happen at that point is the local government can reevaluate its permit if it believes that perhaps it has issued a permit that is in operational conflict with the state, or it can stick with its permit. Once that determination is made, the operator then has a choice to try to reconcile the permits or to go and validate the local permit at the, at the district court. So the COGCC, under this rule, I could envision enacting APD or enacting permits that are in conflict with the local government, because it's saying that that local government permit is in operational conflict. But that's what, that's what they do now. That's what they do after this rule. It's not changing that. Ultimately, though, the arbiter of whether the local permit is valid or not is the district court. And I'm not trying to change that either.
John Golden Dubois.
I think this is one of a handful of proposals that we still have on the table that it seems to me are at the core of this issue about local government's ability to manage these processes in their communities in a way that is consistent with their communities. And I say that because it is one of the few proposals that's still on the table that addresses multiple of the directives contained in the governor's executive order. And by virtue of that fact, I think is worth everyone's consideration. There are a couple in particular that I think are important here that address Jeff's proposal more specifically. The first of which is our charge, as outlined by the governor, is to identify and strive to reach agreement on recommendations for policy or legislation to harmonize state and local regulatory structures as to activities associated with oil and gas operators. And that goes on. It seems to me that one of the two pieces of Jeff's proposal is just that, is finding that harmony between local governments and state governments. The second piece that I think is equally important, that is also outlined in the executive order, is that the governor recommends that we all consider adoption of laws or regulations by a local jurisdiction that are more or less stringent than those adopted by state government. The executive order, of course, goes on to talk about noise abatement. It goes on to talk about air quality and dust management and traffic. I think this proposal catches many of those directives, and I think really captures what is part of the heart of what our duty is here. And so my hope is that people will support this and support it enthusiastically, because I think this is in large part what this task force is about.
Thank you. Mr. Hawley.
Sure, Pat. You're honest question. I'll answer it not from a lawyer standpoint, but just from how the industry sees it. And I can address 2, 3, and 4 all at the same time. And that if you take them to the very end of the line, we really see it as a local veto. And it is local control over oil and gas operations at the end of the day, which is at the very heart of it. As you mentioned, there's the constant flux of requirements from jurisdiction to jurisdiction, which creates lack of certainty in operations. And it also limits, like 20 implies, of being able to prepare well in advance. It's styled as a regulatory matter here, but it really contravenes existing law. And the operational conflict standard has long been a legal principle in the state that provides a limiting threshold for local authority. So if we go stricter than that, then how is there any time when the local regulatory being stricter than the state does not create an operational conflict? Will we go stricter as an industry? Absolutely. And we do that day in and day out. We would prefer to do that in a vehicle like a memorandum of understanding for a specific instant or a specific thing, as opposed to having a statewide thing that we really think defeats the purpose of preemption by the state.
One of my guess thoughts on that, Brad, is that that if you live in you know, the northern part of the northern suburbs, and you look at Louisville, Boulder, Westminster, you know, each one of those cities has a different look and a different desire and different rules. Where do we? I mean, when it comes down to noise and particularly mitigation and sight lines and things like that, those are really important to us. How does our desire get taken into consideration if it's not through a rule like this? I mean, because you do have the sideboards of the operational conflict, and I guess that's been my concern from day one about the advanced planning. My point on the advanced planning was, let's get these things out earlier, and I'm absolutely convinced that Anadarko and Noble and the good operators will work with us, to honor what the local community wants, because I think you already do. I mean, at least I'm told that. But what about the bad? I mean, my very first speech 2 years ago, going back to being in the oil and gas industry, there are good operators and there are bad operators. And what about the bad operators? I mean, how do we in the local, government have some say over those, those bad operators where we have some authority? I mean, and that's really my question. It's not to you guys. It's not to Dan. It's to the operators that are going to be cutting corners, and because that's what they do.
So I would just say, from a personal perspective, I'm very proud of where the task force has come this far. I think that 17 addresses that in urban mitigation areas. I think that 25, the LGDs and the LDLs, moving those up greatly help. I think 7 greatly helps us as well. I think 20 actually helps us in the local process. And I think it helps move the industry forward. And I think we've done that significantly here. I think this is a very different vehicle and a very different tool than all the rest of them that we've talked about today.
Ken Wansel, unless.
It's one thing to talk about dust and noise and visual. The city of Longmont is in court today arguing that its fracking ban is not an operational conflict because there are other methods of completing wells. Now, the fact that you can't complete them economically and you won't drill it is irrelevant according to their argument. So don't kid yourself. This thing is open-ended. That is an argument that the city of Longmont is making today.
Okay. There's no further discussion on 2.
If I could just respond and sort of close up here. So, I mean, Brad, in response to your suggestion that 2, 3, and 4 is a local veto, I would disagree that 2 could ever be construed as a local veto. It's just speaking about land use being stricter than the state, as long as it's not our operational conflict. So there's no real good way for a local government to use that sort of minor authority to veto. I'm going to get to 3 and 4 in just a minute, and then we'll have even more fun. But with regard to 2, I just think that's wrong. And I guess I would point out to the rest of the task force that, I've come to enjoy Brad's company. I think he's a fine person and he runs a great company. But that concept that any local requirement that's stricter than the state is an operational conflict gets to the heart of why we're here. that any local regulation that applied is stricter than the state is an operational conflict, that the local government cannot ever do that. That gets to the heart of why we're here. Because there are communities that are wrestling with this, and they're not trying to do it in a manner to stop development or to ban development. They've put moratoriums in place because they're throwing their hands up because they don't have an ability to enact good protective regulations. That's what this tries to do. And I understand that I will not have industry support because they perceive that anything at the local level, whether it's land use or otherwise, that is stricter is invalid.
With that, would you like to move on to 3?
I'm done. Do you want to turn to 3?
Yes.
Okay.
Let's turn to 3.
All right. So
Now you're on a roll.
yeah. All right. So 3 is a different approach. It's an approach that I floated out as a good idea. I don't believe I ever envisioned that I would have industry support for it. I was pleased that a majority of you fine folks moved it forward for discussion purposes. I would hope that a majority of you would continue to move it forward as a good idea for discussion purposes for future task force, of which I do not want to be involved. And essentially what this does is it treats oil and gas like other extractive resources and allows local governments to zone and use land use authority, and that the operator needs to get a local government permit. This goes further than, than the last proposal. And Brad, to your point, I think a local government in using this, would have an ability to say, no, we're not letting you get that resource out at that place. I think that if a local government were to do that using this authority, they would then have that higher sidebar of a takings claim. And I think that your smart attorney that's sitting behind you would have a good time making that claim if this authority was used in that manner. So in presenting out 4 or 5 proposed recommendations, this was over on the other spectrum. I think I was honest about that from the beginning. I'm maintaining that honesty today. I think it's a good idea for this state to think about. And I would encourage those folks that thought it was a good idea to stay with the green vote.
Any further question or discussion on 3? All right, Jeff, you're on a roll. Do you want to go on to 4?
Yeah. All right. So 4 is a different approach. It's a real legal nuanced approach, and so I apologize for that. But we were tasked with trying to harmonize the state and local relationship, and right now that state and local relationship is defined by the current operational conflict preemption standard, where a local regulation materially impedes the state's interest, it can be found invalid. That's the current definition, and the state's interests are defined to be those goals within the state act. This changes that operational conflict test to a different test. I think it improves it given the operational techniques that exist in 2015. I think that the old test from 1992 was based upon 1992 operational methods. I think given current methods, there are opportunities for operators to do a much better job of locating wells and using the surface in a manner that is more protective of surface issues. And this would change the operational conflict test so that the local regulation is valid unless it materially impedes ultimate recovery of the mineral resource impacted by application of that local regulation. I think that this would improve the local government ability to use their land use and health, safety, welfare, and environmental regulations. They still would not be allowed to use those regulations in a manner that negates recovery of the resource. So we still have a sidebar that I think should be acceptable for 2015 and in Colorado. But it gives local governments that additional authority to protect the health, welfare, and environment of their communities, again, while ensuring that Colorado's mineral resources will not be taken, but rather developed in a timely and prudent manner. Thank you.
Thank you, Mr. George.
Thank you. What does ultimate mean in this language?
My definition of ultimate is that it ensures that the resource is ultimately recovered, it is gotten out of the ground, but it also provides flexibility to local governments to potentially phase so that not all of the resource is gotten out, in the next year or in the next, 2 years, and allows local governments to temper recovery of the resource against the land use and environmental and health safety issues that surround the surface.
Thank you.
Mr. Wansel.
So ultimate recovery does have a technical meaning in the industry. Usually it's called EUR, estimated ultimate recovery, and it's a engineering reserve analysis based on pricing assumptions and other assumptions. It tells you how much of the resource you can get out of the ground and make money doing it. So I guess the question, Jeff, is it's a volumetric measure, ultimate recovery. And as I've mentioned, we're in court with Longmont saying profits and economics don't matter in this. So does this contemplate telling Longmont, you're right, as long as you can postulate a method where you physically can get the reserves out of the ground, the economics of that, whether it cuts your rate of return in half or down by 3/4, are irrelevant?
No, I do not believe that this would validate what Longmont has attempted to do. I don't think it goes that far.
Okay, any other discussion on 4? Okay, we'll move on to, Mr. Hawley, and then we'll move on to number 9.
Just a comment, because phasing was mentioned. Just want to remind the task force that it's a heavily capitalized industry, and it takes millions of dollars to drill a well, and we've got billions of dollars of investment. And when you start phasing that for a very long cycle investment product, when you start phasing that or attempting to phase that, it has a very drastic impact on the returns and the ability to actually develop.
Okay, any other comments on 4? Now we'll move on to 9. Vicki Corliss.
9 remains unchanged, and it speaks for itself. We've referred to it earlier today. I guess what I would ask is if there's anybody around the table who's on the fence about 9, who would join it if some of the language were changed, those are the people from whom I would like to hear.
Any of you out there? Any fence sitters on this one?
See, I'm getting better at this.
Okay. Russ, are you up? Yeah.
Okay.
Okay.
I don't know what harmonized means in this context.
Is there a verb that would jump out at you as more appropriate?
But that, will we take other comments? Okay. Okay. All right. Pat Quinn.
When we were just doing clarifying questions at our last meeting, I'd asked a question that was more than clarifying, and I'm going to repeat it today. I think one of the big issues, certainly in Broomfield, is the fact that the COGCC, first of all, I'm going to say under the direction that I've seen with Matt Lepore in the last 2 years, last 2.5 years since we got involved in the controversy, I think the COGCC, in my observation, has repositioned itself. But in the public eyes, the COGCC is not necessarily seen as a regulator. And I guess when I asked the question last time, getting rid of the word foster, and once again, having spent most of my career in the oil and gas business, I think the oil and gas business does its own job of fostering the industry, and it does a remarkable job because it has primacy pretty much everywhere in the world. I don't, for the life of me, don't understand why we wouldn't put the word minister in as opposed to foster. And I heard yesterday when I was posting this question, there's all sorts of legal reasons for that. But from a public perception point of view, changing that one word is huge. And maybe that's why the industry doesn't want it, because it would change the COGCC from an advocate to the industry, get rid of the dual mandate basically and make it a regulator. But I think that's pretty important for the public to have a regulator of oil and gas industry, and a regulator doesn't foster.
Thank you.
That wasn't a clarifying question, by the way.
Mr. Wonsolin?
Pat, I would just point out to you, yeah, that's a semantic issue, but much more problematic for the industry is Roman numeral 5, which again, we believe changes the existing legal standard. But I would point out just a bit of irony in that the governor's executive order charged this task force to act with particular focus on fostering a climate that encourages responsible oil and gas development, which we will do by removing the word foster from the statute.
Any further comments? Mr. Robbins?
Yeah, oh man, I agreed with Ken on something earlier today, but now we're all in the disagreement stage. No, I don't think, and I think that Russ George hit the nail on the head about the fact that the COGCC has not been fostering oil and gas recovery for 20 years. I think that's what you told me quite a while ago. But I think that the perception is the difference, and I think that this is a very important point, and I don't think that it's going to unfoster development of oil and gas in the state of Colorado.
If there are no further comments on 9, we will move on to number 13. And Mr. Hawley, I don't know if we've already more or less discussed this in the previous conversations, or if there's anything further to be said.
I'll happy to take any questions if there was. I think we had unanimous support, a lot of discussion at the last meeting on this. So.
Okay. Any discussion, question on 13? Dubois.
Brett, I'm sorry, just clarification. I wasn't clear if withdrawal of this was on the table. So can you just clarify what your intention with this one is? Assuming the 17 were to pass.
Yeah, great question, John. At this point, I really feel like that 13 is high level and is kind of important for the foundation of the other ones. 17 certainly goes a lot farther than in some respects as 13. So the proposal, the plan right now, I think, assuming that 17 continues to garner good support, is to pull 13B, but I would like to keep 13 just to end the record.
Okay. If no further comments on that, we'll move on to number 18, which was Peter D's proposal. I don't know if there's any further questions or clarification here. Okay, we'll move on to number 19. Jeff Robbins, comprehensive drilling plan rules.
If I find my notes, we'll go quicker. All right, so this is, again, regulatory, not legislative. It was the idea of allowing local governments to drive the comprehensive drilling plan process. I think this derived from a lot of early discussion about using CDPs as a tool. And my input to the use of comprehensive planning as a tool was that we should let local governments that have routinely used comprehensive planning as a tool for all aspects of their community, to let them drive that comprehensive planning process with input from the state. There were others that had the state driving the process with input from the locals. I don't think this is something that would halt development or actually apply towards specific wells. It's more of a comprehensive look at the local government's jurisdiction, a comprehensive look with the operators at what their plans are, and to try to, at an early stage, allow local governments an ability to, do something similar to what, Pat is saying in his information piece of, here's what we think a good comprehensive plan should look like. So that's this proposal.
Any questions or discussion?
If I
Mr.
may.
Pierce.
Thank you. It's Perry Pierce. Jeff, you touched on it, but I'd like a little more relationship between 19 and 20. Can you give me a little more, please?
Yeah, I mean, honestly, I think that 19 provides local governments with a little more teeth in the game, if you want to call it that. 20, as I read it, is more of an information sharing piece where they get information from the operator. This is more of a local government driven piece in which they go to the operator and say, we want you to help work with us to comprehensively plan what it is you're going to do.
I'm pausing, Jeff, because the current COGCC rules have a comprehensive drilling plan item in them, and I think we have information in our record that next to nobody's ever used it.
That's right.
Does this somehow encourage further use of that existing tool?
What this does is, instead of having the current rule that makes comprehensive planning volitional on the operator's part, where they go to the state and they submit a comprehensive plan, which has not been used. Instead, this would allow the commission to recognize that local governments can require comprehensive planning if they think it's a good idea. So it gives the local government the ability to drive the comprehensive planning ship.
Okay, thank you.
Any further questions?
Steve, again, it's volitional. No. You were looking at me.
Mr. Hawley.
Jeff, do you have ideas here on how this could be less complex and less arduous for both sides? And this, is there time limits, or is there anything along that we could put in there? Because I think to Perry's point, the reason it's not used today is fairly obvious.
Yeah, that just sort of goes against the way I do recommendations is I have trouble getting down into the weeds, and maybe it's because I'm a local government lawyer, and one local government that I might represent will want to do something fairly simple. Another local government might want to do something fairly complex. And so I've tried to keep most of my recommendation at the 30,000 foot level to allow for that flexibility. And I know that's something that you're not happy with, but it is what it is.
Any further discussion on 19? If not, we'll move on to 22. Again, this did not see any changes as well. Any questions, comments? On Solon, any further explanation needed? Mr. Tour.
So on this one, this is another one where I want to make sure that I understand what it actually implies. So it would require consultation with mineral owners when considering some type of land use approvals. And I'm a little unclear whether, when it talks about significant surface development projects, so this would not be at the comprehensive planning, during your comprehensive plan process, but would be when an application comes forward for a large development project? Is that the intent?
The existing statute has really two parts to it. One is any project requires notification, any surface development project that meets this definition of application for development, and that excludes things like lot line changes and things like that. So it's some, new development on the ground coming in. Requires notification of the mineral owners who may be affected by that surface development. For very large projects in the greater Wattenberg area, it goes beyond just a notification, and requires basically the parties get together and work out an arrangement for both existing wells and potential future wells. So the recommendation here is to expand that actual consultation process beyond just the very largest developments in the greater Wattenberg area only, and have it apply more generally in the front, statewide actually. Now, that's going to take some amendment to that statute. Mr. Furstein and I sat for about 2 weeks leading up to Christmas, I think in 2006 or 7, and worked out the first version of this bill. And it really was focused at the time on vertical drilling and directional wells. It relied somewhat on the greater Wattenberg area drilling windows. So I don't see this as something that moves ahead quickly. I see this as something, if the governor and the legislative leadership are interested in pursuing it, that they have people like Randy and myself and some other attorneys sit down and maybe come back in 2016 with some changes to that existing statute that make it of more general application and use. So it is triggered by the surface developer coming in on this.
And the intent would be simply to expand notification and consultation, not to require anything beyond that?
I'm not sure you mean not to require anything beyond that. In general, the way it works now, where you have to go to the consultation process, the local government doesn't approve the subdivision until the subdivider developer comes back and says, either I have a surface use agreement, I worked it out with the operator, or the statute currently provides a statutory mechanism to group well sites and says where they go. Again, that was designed to address vertical wells, and it's not going to be immediately translated to multi-well horizontal drilling. So this is, I think, just, it makes sense to update the statute to take into account the kind of development that's going on today, move it beyond where it's restricted to today. But it's going to take an effort over the course of the next year, I would say, come back in 2016 with an update to that statute.
Okay, Mr. Golden Dubois, Mr. Sura.
Ken, I'm just a little confused on this one. So I guess if you could take this one to a practical level so that we can understand what this would mean to different, I guess this is in particular dealing with mineral owners. What does it mean and what does that look like that's different than today? I guess I'm having a hard time conceptualizing that.
Didn't hear for what looks different?
Yeah, well, I don't understand what's different than exactly how this process works today. So if you could walk us through a specific instance, that would be helpful just to get my head around it.
Today, if the surface developer and the mineral owner / lessee cannot reach agreement on where to place the facility, let's say in a belt or something, then the surface developer has the ability under the statute to restrict the locations that would otherwise be available to the operator pursuant to the Oil and Gas Commission rules. That is, they can take away some, maybe up to 4 out of the 5 greater Wattenberg area drilling windows that would otherwise be available, and force the operator to group their wells in one of those windows. The statute currently requires that the surface developer pay approximately $90,000 for the incremental cost for each of those wells. But again, that was designed in the day of vertical and directional drilling. So it really, it's a mechanism to get surface developers talking with oil and gas operators. It actually came out of a situation where both sides had competing ballot initiatives back in 2006, and Governor Owens brought us into a room and said, knock it off, drop these, sit down, talk, and this was the bill that ultimately passed in the legislature after Governor Ritter was in place as part of the big package in 2007. It's out of date. You know, we're not drilling directional wells and incurring incremental cost. So the idea is to update this statute to account for modern development.
Mr. Sura and then Mr. Rao.
I don't disagree that this statute is a problem and it's out of date, and I agree that it needs more work. And I think I'd love to help in 2016, but I think it's kind of half-baked at this point. And is not well thought out enough, and we don't have enough details to really push anything forward at this point.
Mr. Rao?
I would just add that I tend to agree it's also out of date. I think we've had a number of conversations around the challenges to that. And I guess I would say that this proposal as written, combined with 10, really started making me nervous. And I think that what I like is the description that Ken gave of what needs to be reworked. I don't see a lot of that in this proposal. And so as it stands, it makes me quite concerned that you could have a situation when combined with 10 that would alter or substantially increase the leverage that industry would have in this case. The idea that notification ought to be expanded, I don't have an issue with that, but I think this sort of broader discussion of dealing with that outdated legislation requires a lot more than the number of words that I see on this paper, and I think it causes me real concern moving forward without that broader discussion.
So just keep in mind, as we've heard, this is a high-level recommendation, and I think keep in mind what Russ George has said. There's a long legislative process ahead before this ever moves, and all those issues will be brought forward if the legislature decides to go down this path. And there's no guarantee that's the case.
Okay. Any further questions? Mr. Golden Dubois, Mr. Sarah, you're addressed? Okay. We have already addressed number 27, 31, and 34. So it suggests we move on to 44 and 44A, which I believe originally were a single recommendation that have been split into two by Ms. Corliss addressing surface owner issues.
So I am perfectly happy to answer any questions. The fundamental thrust, both of the statutory recommendation and of the regulatory recommendation, is really twofold. The first portion of it is to assure that surface owners who are burdened with the duty of access nonetheless receive damages for the operations that are conducted on their surface. So there's no windfall here. This is purely damages associated with the actual operations. The second portion, and that's to address the concern that I spoke to earlier, the push-down pop-up, where these sites are going to be moved to locations where there's a little less pushback from the community, and they may well be in places where a particular landowner bears the brunt. Now, the second portion of the recommendation addresses the circumstance where the surface owner is not burdened by an access easement, and making clear that under those circumstances, the surface owner still retains the right to negotiate in good faith on an arm's length basis as to whether it wishes the operations to be placed on that surface estate, so that we don't inadvertently trip into this notion that we are somehow expanding the accommodation doctrine to include a lot of surface estate that would not otherwise be burdened. As a practical matter, I don't think we can do that. I don't think that we could change the law in that regard. But conversations over the last 5 months have convinced me that there's a significant amount of confusion out there as to what the surface owner is required to accommodate and what the surface owner is not required to accommodate. So these proposals are an effort to clarify that, not to change the law, but to clarify that.
Questions? Mr. George and then Mr. Wansel.
Let me try to do this by...
You got to turn your mic. There you go.
Do this by an example. If I own 40 surface acres that can be fully drained of underlying gas with one well, is that the only requirement that I can be burdened, that my surface can be burdened with, is that one well?
It depends upon the specific language of the reservation, Russ, but generally speaking, my view would be yes, that is the sole extent of the actual burden that is placed on that surface estate. Beyond that, it's up for negotiation as to the additional wells that you permit, the additional horizontal drilling that you permit.
Thank you.
Mr. Wonsall?
So just some clarifying questions. Legally reserved, you talked about a reservation. You're talking about a reservation in a deed or a patent. How about in a other conveyance, is a lease something that legally reserves access?
Can both legally reserved and burdened were an effort to capture the notion that Russ and I just talked about, namely that the accommodation doctrine only pertains to that instance in which there is a legal burden on the surface estate to permit access. Again, I'm not trying to change the shape of the law in that regard, but merely to clarify it. So I have a sneaking suspicion that there is no language here that would cause you to suggest that your principal vote for this. But if there are those of you who are interested in amendment or clarification of the burden language or the legal reservation language, I am definitely all ears in that regard because I have no particular pride of authorship.
Well, I do want to explore the implications here, though. So under Colorado law, even if a legal document does not expressly or explicitly reserve access to the minerals, there is, under Frankfurt v. Adams and other Colorado cases, an implied easement to go develop the minerals. So does this take away the implied easement under Colorado law?
As to the minerals underneath the surface estate, I would suggest no.
Okay, and then reasonable damages, you know, there are kind of two measures that have been used by those states that look at this. One version, which I think maybe the Wyoming version, says you look at if the operator uses 10 acres, you look at those 10 acres. Another version says if those 10 acres are part of a 100-acre parcel, you look at the overall diminution of value of the entire parcel, taking into account the development on 10% of it. Which of those two standards are you trying to accomplish here?
Well, Ken, my view of this particular recommendation, and I don't want to dig us into a little black hole here. I recognize that this is not the seminal issue before all of us, but my view of it is that making the surface owner whole is what this should be about, so that the surface owner essentially becomes a partner to the operator, that the surface owner is not sacrificed or run roughshod over, or however you wish to speak to it. This is not an effort to visit a windfall upon the surface owner, to buy him a lottery ticket. It is rather an effort to make sure that whatever use is being made of that surface is protected and compensated for by the operator. And if it's one well in and out, obviously that's a very different sum of money than if it's a production facility. So I would not attempt, and I, like you, I'm aware of there are different standards between Oklahoma and Utah and Wyoming and other states that have adopted surface owner damage statutes. I'm not intending to grab hold of one of those over the other. I am intending to create a mechanism by which damages are anticipated and paid to the surface owner who is burdened by the well.
So final question following up on what Russ said, and I think I heard you say this, so you indicated if one well could drain a 40-acre parcel, that would be the extent of the burden on that surface owner. So how, are you basically saying that pooling goes away? And
No.
that once you have a drilling and spacing unit,
No.
you cannot have wells that drain minerals?
No, and
other
that's why
than-
I'm concerned about your pooling recommendation. No, I'm not saying that.
I don't have a pooling recommendation.
Okay, somebody does.
Okay, Kent Pepler, please. And then we have Perry, Jim, and Bruce.
I think we're going to support, or I'm going to support this.
Rebecca makes some assumptions, I think, that what we're doing on this task force and where the industry's headed will increase the pooling and will increase the mining of more than one parcel of land from a particular parcel of land, as what she's been saying. And we're seeing a lot of that now with the horizontal drilling. We have a place that's 80 acres that we only have 25% of the minerals, and that's 20 acres of minerals that we have, and they're gonna mine 640 acres worth of minerals, and we only get the benefit of 20. So in that particular instance, we were able to negotiate a no construction clause on our farm, and we have some neighbors that are desperate enough for oil checks that they're willing to put up with a tank battery. So that's one example of mitigation. But the other one is too, we have another place that's got 80 acres that's gonna do 640, and the tank batteries and the wells are gonna be on our place. And certainly we're expecting more compensation from that, because we're dealing with more people's oil and gas than just our own there. So we're going to support it, and I think Ms. Corliss's assumptions are exactly correct.
Perry Pierce?
Thank you. This is Perry Pierce. I want to express my concern that I sort of touched on at previous meeting. I am particularly concerned with the last phrasing of item 1B, which essentially says, even if the minerals under your tract of land are leased by an oil and gas operator, you can refuse to allow a location on your site. I think that is a significant interference with what is understood as a property right.
Where do you see that, Perry? Because that's
The
not...
surface, under the condition where it is not reserved, the surface owner is free to determine that it will not permit the operator to enter the surface.
But if it's your property and they're drilling Russ's minerals, of course you don't have to permit entry onto your property. If it's your property and they're drilling the minerals...
Yes, but if they're drilling through a horizontal well, they're drilling my minerals and your minerals and Dan's minerals and Steve's minerals. I'm not sure that this language taken together doesn't say you can only drill a well to access the minerals under my surface estate.
And my position would be that in your lateral hypothetical, it would have to be pooled for you to do that. And if it were pooled, then the surface owner is stuck with it.
Is a pooled mineral estate a reserved right?
Legally reserved right of access. That's the language Ken and I were talking about. And whether that does include pooling or unitization, it should.
Thank you.
Okay, Mr. Rao.
I'm just going to start off by saying that this is an important concept, as you all know, to me, but I think it's also important to the ultimate outcomes of the task force. And I say that because in a number of proposals, we have supported this concept of pooling, the concept of larger units for the specific purpose of trying to achieve a surface location that has less impact to the larger community, which I think is a laudable goal, and it's one that I support. Having said that, the consequence of it is that certain surface owners will be disproportionately impacted. Example that Kent gave me earlier today as we were talking was, you know, if we're drilling around the edges of urbanized areas, it's the people he represents in his own farm, right, that are more likely going to be impacted than would have been otherwise. And so I think the only way that we can really support that solution is if we also support the solution to the problem that it generates. And I think it's important that we link those together. I think it would be improper to do one without the other. Moving on beyond that, I think the conversation, Perry, that you and Rebecca just had, I think it's a really important one. And I support the answer that you guys came to, which is, you know, to the extent that they were brought together, then, and again, the whole purpose from my perspective is to get to the right surface location And if the minerals are all brought together and drilled together, then I think you can do it. You just have to come up with a reasonable mechanism for achieving compensation for that surface owner. I just think that it's critical. I think finally I would say that, and I've said this before, but I think it's important to remember, the change in technology in the industry that has allowed these long horizontal wells has had two consequences. One, it yields an outcome where only one of many surface owner takes the impact of the surface. It's exactly what Kent just described going on his farm and he sees in other places. And the other is that when that impact occurs, it's a much more intense impact. And because of those two factors, I think that in order to preserve the substantial benefit for the state and for the industry and for our communities of the consolidation and of the long horizontal wells, we have to arrive at a solution to address the differential impact of the surface owners. And I certainly support this proposal. I think, I don't know, Rebecca, if you're going to make any adjustments to deal with the question that you and Perry were having, but I think that's an important one to resolve. Thank you.
Mr. George and Mr. Wanstolen, are you still up? Russ, is your card still up? Right. Mr. Fitzgerald, last comment on this. Okay.
This is a real basic question, Becky, that just deals with my experiences down there. When the industry, and I don't know whether this relates to it or not, but it might. When the industry comes in there and they say we're going to take a pad, 1.5 acres, 2.5 acres around that place, they make different offers to different people for how much they're going to compensate. And they frequently say, we're not required to compensate you in any way for the space that we take up. And yet they do. Some of them maybe as much as $30,000 for an acre pad or that area, others $2,000 for an acre pad. And it all seems to be mysterious. And so I'm interested in if you can help me understand that process.
I can't help you understand the process other than to agree that it happens. I think that, Jim, the operators who take the position that they don't owe anything are flat out legally wrong. It used to be that a lot of operators took that position. I don't think that's the case anymore. I think there is a much more robust acknowledgement of the need for a surface use agreement. But the bottom line of the law is that if an operator cannot come to an agreement with a surface owner, they can bond on and sort of surface owner be darned. That is perhaps an appropriate end analysis, but I think it has to be preceded by the expectation that damages will be paid to that surface owner. They have lost the right to say no by virtue of the reservation of access, but they haven't lost the right to continue to use their property or to be compensated for the use of their property. That's how I would address it. Not really, John.
Okay. Is there no further comments or questions on this? We'll move on we have a suite of disclosure or 2 disclosure proposals. The first is number 42 from Gwen Lackout, and that did receive some minor revisions.
Thanks, Sarah. This is Gwen Lackold, and there are a couple of changes from this draft from the previous one we considered on February 3rd. In reviewing other states' chemical disclosure requirements, I found California's and Wyoming's could serve as perhaps a model for a few improving some aspects of Colorado's disclosure rule. And those are mainly in what must be disclosed and when disclosures must be made. So just very briefly, this disclosure requirement would require in the following instances: before drilling, fracturing, and workover operations, operators must disclose the complete list of names, casts, the chemical abstract service numbers, and maximum concentrations in percent by mass of each chemical added to the drilling, hydraulic fracturing, and workover fluid, as well as the trade name, supplier, and purpose of each additive, the total volume of fluid used, and the amount of fluid flow back that was recovered. And Colorado's current requirement on when disclosures must be made is 60 days after completion of hydraulic fracturing operations and no later than 120 days after hydraulic fracturing treatments. My proposal is that disclosures would be made as part of the permit application and 30 days prior to treatment to surface and adjacent surface owners and to emergency responders, and then also the complete list 30 days following the oil and gas operation. So really it's trying to improve and borrow from some of the better requirements that other states are now requiring of chemical disclosures. I'll entertain any questions.
Mr. Pierce.
Thank you, Perry Pierce. I think I see a significant time problem. The second sentence talks about disclosing information before drilling, fracturing, or workover operations. I would ask the operations, oil and gas industry folks here about when they know the information that you seek, and I am sure that we can't tell you the volume of fluid we use nor the volume of fluid we recover after fracturing before we do the frac job. I mean, that's just not possible, so.
Okay, just in response, California requires disclosures to be made 30 days prior to treatment to both surface owners and 60 days after completion of hydraulic fracturing operations. And then Wyoming requires disclosures to be made before. And this is part of the permit application, and then 30 days after the operation.
I believe you would find that in each of those instances, what's required is some sort of what you expect to use here rather than absolutely what you're going to use. As I understand it, fracturing formulas are sometimes changed day to day on locations, and I am fairly confident that Wyoming allows you to submit reports which provide what you expect, and then after a period of time after drilling, you allow and are in fact required to amend that filing, and that provision is not in this suggestion.
Okay, Wyoming's requirement is before, it's part of the permit application, and then 30 days after, what was actually used. So this language mirrors Wyoming's language.
Mr. Rao, do you record it?
My question was actually in the transition. Are we skipping 44A?
Sorry, 44 and 44A were addressed.
Discussed together, I think.
Okay.
Sequentially, yeah. Did you have a comment on 44A? We can come back to that after this conversation if we need to. Okay. Mr. Wanstelan.
Gwen, although it doesn't say it explicitly, I presume you want to eliminate the trade secret status of any of these chemicals. Is that correct?
That item is covered in Mr. Dubois'
Okay, because I know in Wyoming, although there is advance notice of what you intend to use, the director of the Wyoming Commission actually makes some determination as to whether or not a particular chemical can be retained under trade secret status.
Yes, the actual Wyoming language is that it requires, they do provide for trade secret protections if it qualifies under Wyoming statutes, and under penalty of perjury, the operator provide specific information on measures taken to protect confidentiality, commercial value, and potential harm. And the supervisor determines if information is exempt from disclosure.
But you're not addressing trade secrets in your proposal?
I am not addressing trade secrets in
I'll
my
defer that
proposal.
comment to you, to Mr. Golden Dubois.
Any other questions or comments on this? Number 42. Do we need to come back to number 44A first? Oh, sorry, Russ.
I'm sorry, I was just trying to read what you're saying here and square it with what you just said out loud. You're not attempting to reach trade secrets, but you are reaching, and your language is confidential business information. So what's the difference?
Well, again, my proposal calls for the full and public information of the chemicals used. So I didn't specifically go into trade secret exemptions because it was addressed in another proposal. But we did discuss full and public, and Mr. Lepore tried to assure that we did have full and public disclosure, but we do have trade secret exemptions. So
I guess I'm just confused because in your rationale, it would lead one to believe you are trying to reach confidential business information, which is another term for trade secrets, is it not?
well, that's the language in the Colorado statute that allows companies to not have to fully disclose all of the chemicals used.
Okay, I'm still confused. So are you asking to move past that and require that confidential business information to be released or not?
I think that we need to achieve full and public disclosure of the chemicals used
So that's a yes.
in oil and gas operations. I didn't address it specifically
Okay,
as
well,
trade secret.
that isn't the answer you gave to Ken. I'm just confused.
Well, you're saying there's no trade secret exemption.
There, under this as written, there wouldn't be.
There would not be.
There would not be.
Okay. But you quoted Wyoming, and Wyoming has a trade secret exemption.
They do.
I mean, you said they did. I mean,
Yes.
I'm not giving a fact independent of you. Why did you choose not to follow Wyoming statute the whole way if you thought part of it was good and not the rest?
I think it's different to use language, full and public disclosure. I think that that's what the public deserves. People that live in communities, I think they deserve the full disclosure of what's being trucked through their communities. And my community learned that the hard way in having a nurse nearly die after being exposed to fracking chemicals. And the company still has never revealed what she was exposed to.
Does any industry representative want to comment on that?
So I guess it's not quite as explicit in 42.3 or 42 as it is in 43. So I guess the same point will be germane to both, though. Colorado in 1986 adopted the Uniform Trade Secrets Act. So how is it that by rule, the Oil and Gas Commission can adopt a rule that contravenes the provisions of that act?
I believe Mr. Kelly raised his card to that question. And again, I think Gwen's been relatively clear on the intent of what she's trying to do here. So rather than debate that intent, just want to make sure people are clear on what it says.
Could I get an answer to the question I just
Okay.
asked?
Yeah, go ahead.
And Mr. Golden Dubois, free to chime in because you're quite explicit about you want the commission to revoke the trade secret protection provided by statute. So the question is, how does the Oil and Gas Commission act in contravention of state statute?
I'd be happy to answer that once we get into the discussion on the trade secret exemption one on my proposal. It seems like we should address this one fully first and then come to that because that mine is an explicit repeal of the trade secret exemption.
That's fine.
Okay. Mr. Kelly and then Ms. Corliss.
So I'm not sure I'm going to be able to, we may have to repeat the question again and make sure that I've got it right. But I can't speak to the issue with the chemical exposure and a person almost losing their life. I certainly can't touch that. I have no knowledge of that. I do have years and years and years of history with pumping chemicals and mainly water and mainly sand into the ground and in the hydraulic fracturing process. So Mr. Quinn asked what our experience was with that, or do we have experience with that? And never have I seen any exposure to any of those chemicals cause a health concern that was anywhere to the level that Gwen talked about. When I look at this, and with full disclosure, we believe transparency is very important. And we believe that there's a lot of issues around the chemical conversation that for reasons that the oil and gas companies could be more transparent, we could allay some of the fears that are out there. But there is a line that I'm worried about crossing to where competitive advantage is lost at all levels when some folks have really worked hard on their technology, have brought certain technologies forward and advanced that, and really tried to do a better job than the other operators. And that's all for naught because of this full and complete disclosure. And where I come off on that, if we were seeing the harm or we were seeing the effects that people talk about, I could certainly get my arms around that. But because we do this on, a very frequent occasion, many times a day, we don't see that impact. I do worry about competitive advantage here and where that leaves operators going forward. So I just wanted to make sure I stated that.
Ms. Corliss.
So my comment is more one of clarification. As I understand, either or both of these, Gwen and John, they speak to, in some combination, 3 different points. The first of which being the expectation that the chemicals would be disclosed prospectively, and second of which being they would be disclosed more quickly after the fact. So that which you anticipate to use or anticipate using, that which you actually did use on a shorter time frame, and then yours explicitly, John, and perhaps implicitly, Gwen, the revocation of a blanket confidentiality provision as to trade secrets, or however we might want to couch that. Are those the 3 thrusts of the recommendations?
Go ahead, John.
Yeah, I would just
wait for him to get back. In the meantime, number 35, Jeff Robbins on noise, no further changes. Any further comments or questions, discussion here?
Jeff Robinson, just to reintroduce the task force, this is a fairly simple proposed amendment to state statute, which currently prohibits counties from regulating noise associated with oil and gas operations. We've heard that noise is one of the most disruptive elements to neighbors to oil and gas development, and this would be a statutory amendment that would allow counties to regulate noise.
Mr. Moreno, are you up? No, okay. Any other further questions or comments? Mr. Tour.
A clarification, so currently cities have this authority and counties do not?
Correct.
Okay, any other comments, questions? Okay, number 36, Mr. Golden Dubois, I believe you had some changes you wanted to suggest to this.
Yes. Let me pass these around.
There's two of them?
Yeah, there's two of them. So you have a copy that has strike through, and you have a clean copy that represents the new version. Number 36, you'll recall that this is an attempt to amend some of the existing rules regarding electric drilling rigs, noise suppression, dealing with noise overall, and some other issues on safety purposes. When I brought this before the task force previously, the industry expressed two specific concerns about the proposal. And that was that in some instances, or even in many instances, it may not be possible to have electric or natural gas powered rigs. So I've added in the two words wherever practicable into that proposal. And the other major concern that was raised at the time was the safety issues that would be caused by eliminating the vehicle backup alarms. That section you'll see has been stricken. And other than that, the proposal holds firm. This is an attempt to try to deal with some of the noise and other issues that residents have experienced when they're in close proximity to oil and gas development in their communities. And I will take questions.
Any questions, comment, or discussion on this?
Yes.
Mr. George.
Second paragraph, for safety purposes, amendments should. What's the difference between should and shall in this context?
Well, I think that's a good question. As you'll recognize, much of this was drawn from the Colorado Department of Public Health and Environment's recommendations on several large-scale sites that were in close proximity to communities. That could be read as, and changed to could, if that is more amenable.
My point is that you helped paragraph 1 with several pieces. And 2 seemed as proscriptive to me in the original draft. And until I say it isn't shall, so that it'll be in the, be such that if you can do it, if it works, if it makes sense, if it's practicable, it's a best practice, all of those qualifiers that we always use for these big investments. And so that may make a difference on how we read the prescriptive degree in paragraph 2. I believe most of what you're talking about here into is best practices. There is movement towards it. It's technologically helpful. But I think it's hard for us to tell industry, you will do these things no matter where, no matter what the cost.
I hear your concerns there. I guess what I would say is that it is my intention, as much as possible, to drive best practices to become standard operating procedures, and tomorrow's best practices to similarly become standard operating procedure. I do want to drive that conversation. I also want to make it possible to comply. So I'm open if you have suggestions there.
Mr. Tor.
John, on this one, is the intent that this applies everywhere, or is the intent that this applies for large operations in proximity to residences?
It's, in particular, its attempt to deal with those large operations and dealing with the scale, the proximity, et cetera, that we've discussed on many occasions. I do think, though, that best practices are best practices, and we should be conscious and we should be making an effort to improve those practices everywhere throughout the industry. But it's particularly targeted towards some of those larger scale facilities.
Mr. Rao.
Thank you. So, when I read this, I think, and actually also read the letter that you'd referenced, John, from CDPHE, and I think that applied to a specific circumstance where there was a significant impact that was in relative close proximity to development. And under that particular circumstance, particularly with the size and scope of the proposed development, I think it made a lot of sense. And this proposal is written really, without saying anything different, appears that it would apply statewide in almost all circumstances where it could be done. And I think that's where it goes a little bit too far for me. In fact, this feels more to me like one of the positive options in one of our other proposals for enhanced mitigation measures, where those enhanced mitigation measures are appropriate. And I think you're right, John, in saying that the more often that a solution like this is utilized, the more cost effective it becomes and the more capable the industry is of utilizing it on a wider basis. So for that reason, I would support the concept, but I think it is more appropriately addressed in enhanced mitigation measures in one of our other proposals, as opposed to a standalone proposal that is, I guess, in my estimation, too broadly applied.
Mr. Fisher.
Thank you. John, just a brief comment. This covers a number of things. I like the concept, but I get nervous about some of the details. And one of the details is the same one that Bruce just mentioned. It's applicable across the state, and regardless of the intensity or scale of the activity. And it just makes me nervous because I don't know enough about all of those things to feel comfortable about this. And I don't even have sufficient confidence to ask you what my change would be. But that's what I'm struggling with on this one.
That's okay. Even if you don't have a question, I have an answer. I would hearken back to one of Mr. George's comments earlier, is that it is not my intent to specifically prescribe in a regulatory process that I would envision this would have to be considered in exactly what the actions of the COGCC would have to be. It is merely a set of ideas that I think the COGCC should consider and should have in their deliberations as they go forward. So I think this is one of those sets of recommendations that is broader in nature. I understand that. It does represent much of the best practice that the leaders in the industry are doing, and it would be subject to a rulemaking at the COGCC.
Okay, no further comments on this one. We will move on to number 37. Again, there are no changes to Mr. George's proposal on a traffic stakeholder group. Any further comment or question?
Anyone who votes for this gets a free pass on not having to sit on the study group.
Mr. Rao, is your card up on this one? Mr. Busher, you up on this one? Okay, we are in the home stretch on the last page of our handy chart here. We've already addressed number 49, the methane rules. If there are no further questions or comments on that, we will go ahead and move on to number 39, John Goldenblatt's proposal on groundwater quality and soil monitoring. Again, no changes in this proposal.
Yeah, so this is an attempt to add groundwater quality monitoring to an area that has heretofore been skipped in the larger COGCC regime. So many of the other facilities that we're talking about, wells and the like, already have water quality monitoring along with those wells. What has not been dealt with is some of these larger facilities, the processing facilities that we've discussed, that much of our conversation has been focused on. So this is an attempt to have water quality monitoring on those larger processing facilities where there currently is not existing monitoring regime in place.
Ms. Wedgeworth, did you have a comment on this one?
Kind of cruise past 49. I just want to
Okay.
make sure that the recommendation highlighted language is.
Okay. Well, let's come back to that, just since John has just introduced this, we'll come back to 49 and make sure.
Yeah.
So, okay, so let's go ahead and discuss 39. We'll come back to 49 and make sure that that's clear. Mr. Hawley.
Yeah, John, does 39 qualify the larger facilities, or does it just apply to all production facilities? So I'm trying to find the definition there where it
It's intended to get to larger facilities. I think your question is a good one, since I don't think we have a clear definition overall of what constitutes necessarily this came up in several of the proposals, Bernie's in particular, number 17. So we didn't actually define exactly what those facilities look like. So I think there's going to clearly have to be some definition put around what are we talking about when we talk about large-scale facilities, when we talk about multi-well production facilities, when we talk about production facilities. I don't have the answer to that, Brad, but I think that would be an appropriate question for the COGCC to deal with and to create a definition for what that means.
Mr. Rao, are you up on 39?
So I think in our last meeting, there were a number of people that commented, and I took it to heart that I think this falls in the midstream category of oil and gas development, that those businesses really weren't represented on this task force. And in fact, we haven't had a lot of discussions around midstream issues. I think I support the concept that, it's reasonable to try and do appropriate things to protect groundwater and surface contamination. But as written, this is fairly specific and gets into an area where we don't really have solid representation on the task force to address the issue. It seems to me that it's a valuable recommendation nonetheless. And I would say that my support for this sort of recommendation would be tempered, or maybe conditioned is the word I'm looking, on dramatically simplifying it to the point of basically establishing that we think it would be a good idea to have rulemaking on this issue. Because I think beyond that, we really haven't addressed the issue at enough depth and don't have appropriate representation on this task force to get into the greater detail of the proposal.
Okay. Mr. Hawley, are you, okay. Any further discussion on 39? Okay, coming back to number 49, which we touched on briefly in the health rules, again, wanted to just clarify the changes that were made there, Ms. Wedgeworth.
Yes, I just wanted to make sure that the recommendation that was amended for this, the General Assembly should approve SB 15-100, the 2015 Rule Review Bill endorsing all new rules not otherwise legally invalid, that language be eliminated and has its stand as is.
Any questions, clarification on that? Okay. Okay, 52B, again, had no changes. This is Becky Corliss's recommendation on a compliance assistance program. Any further discussion, questions, comments needed on this? Okay. Number 53, Mr. George's proposal to delay further rulemaking until existing rules go into effect. No changes have been made to this, any further?
There's no change, but just think about what could happen when we adopt any number of these recommendations and what that means to the rulemaking staff and processes. And regardless of where you come down on the side of in any of the material issues, one of the things that you want to be cautious about is that if you keep changing the rules all the time, it's harder for even people in good faith to comply. And as complex as all of this is, I just thought it was worth reminding ourselves that just because there's a lot of concern and maybe in some places panic, doesn't mean that the way we recommend changing the law is the best solution for the time. The law is a tool of limited value. You have to be careful how you use it, and you have to give it time. And so that's the context in which I leave this one standing in front of you. Clearly, if this is in the works as a recommendation, it suggests to the rulemakers that they're going to need to prioritize. And pieces of the existing rules that are clearly already obsolete shouldn't be covered by this, of course. But other pieces that would still have some positive relationship to what we're doing here, or still make sense but need time, those are what I'm talking about. Give them a chance.
Mr. Torrey.
Perhaps unsurprisingly, given my comments at the last meeting, I'd like to speak against this one. And again, Russ, I understand what you're trying to do here, and I see some logic to it. But given the issues that we're trying to address, I think that we shouldn't be discouraging the regulatory agencies from trying to address those issues. And, you know, the science is constantly changing. We keep learning more as we go forward. The fact that we've done rulemakings in the past does not necessarily suggest that those rulemakings shouldn't be updated, even in some cases within a few years after they were originally passed, if more information has come to bear and if conditions may have changed on the ground. And I think that given the dramatic expansion that we've seen of large production facilities in residential areas in the last few years, conditions have changed substantially. And, you know, so I would urge the task force on this particular recommendation to not move it forward.
Any further comments, discussion? Okay. Rounding out the end of the list, there is Gwen Lackel and Bernie Busher's proposal on the ombudsman process and position. Again, this received no changes between the last meeting. Mr. Busher and Ms. Lackel, did you want to?
No changes. I think this is a fairly simple and straightforward recommendation. We heard a lot of folks concerned about inability to get answers to their questions regarding oil and gas activities, and this is intended to help that process. We required that the ombudsman subscribe to the International Ombudsman Association Standard of Practice and Code of Ethics. I would take any questions.
Ms. Corliss.
So Bernie and Gwen, the first question I have, which we've already sort of addressed in passing, is the extent to which this really is to some extent duplicative of the information clearinghouse that Perry proposed. But the second question I have perhaps goes to the heart of how it wouldn't be duplicative, and I'm not sure whether this concerns me or doesn't, but it seems to me that it could set up kind of a fiefdom of somebody who purported to know everything about everybody's rights as it related to oil and gas development, be it, you want that role, Perry? Be it the local government designee role or the surface owner's rights or the mineral owner's rights or the operator's rights. And I just worry that this is so complex that asking that of one person and suggesting that he or she would sort of hold themselves out as understanding how all these pieces fit together and what a particular individual or entity's rights might be is a tall order. I'm not necessarily opposed. I worry about it a little bit.
I think those are valid concerns. The fiefdom issue happens all the time in state government. I think we've all seen it. It can only be remedied generally by good management. Whether or not one individual can handle this, I'm not sure. It is not limited to one individual. In some of the other states that I looked at, Utah specifically, they have 3 attorneys and an assistant, I believe a paralegal, that assists in dealing with property rights conflicts. And perhaps on this, I'm using Russ's approach and doing it from 30,000 feet rather than from the details that need to be done at some point.
Ms. Sackel?
Yes, I would be very concerned if Perry became our ombudsman. I guess in trying to address your question, we combined my proposal and Bernie's proposals, and we really didn't get into the weeds of how this office would be created. I think in a state that's as large as Colorado and with as many wells, I think it'd be a very difficult job for one person. And perhaps there could be an interesting way to configure it similarly to how Utah has done it. Bernie contacted people in Utah. I contacted an ombudsman in Alberta, and it's very interesting to see how they've been able to complete their tasks and do it in a way that's impartial and holds people's information confidential. I think that's really critical. That's one concern I have about a clearinghouse idea is just, could you achieve that impartiality and confidentiality in an office that didn't have strict standards such as an ombudsman or ombuds? I'm not sure what the gender neutral term of ombudsman is, but I think it's ombuds. So I think more needs to, we need more thought into how this would be created in Colorado, but I do think it's really critical given all of the public testimony we received over the need for more and better information, and to really, for this task force to really think about what follows when we're finished, and could we put something in place that could truly be a resource for the people of Colorado.
Ms. Berwinski?
I just want to echo that they really are 2 separate tasks, even if they are coordinated well. In my former life, I did work in Missouri about creating an ombudsman office for child abuse and neglect. We already had a clearinghouse for information. Absolutely, they need to relate to one another, but their tasks are totally different, and it would not be appropriate for the same person to be doing both. The same people have to have access to the same information that the others does. And whether that's housed in the same office to facilitate that is one question. I don't think that's essential. I think it's an option. But I think your instincts that these do not collapse well is true to my experience.
Mr. Fitzgerald.
The thing I particularly like about the ombudsman as opposed to a clearinghouse, although I think they both could work together, is you're talking about a real person. And somebody's in trouble or has problems and they want to get a hold of somebody who may not necessarily be an expert in the area question they're asking, but can tell them where to go and how to get there, which is what I think they'd be doing. And obviously, if you had an ombudsman, that would be a person who would know best how to set up a clearinghouse of information, and that could grow organically over the time. But when you're used to trying to get a hold of somebody and you get press 6 if you're this and press 4 if you're this and press 2, the idea of a real ombudsman who might at least sympathize with you while you're crying or something is appealing to me.
Any further questions or comments? Okay, I think we have made it through every proposal. Congratulations. Christine's going to walk us through the process from here.
All right, we are at 3 o'clock. We're going to give you a break, and during that time, all of you can contemplate whether or not you would like to revise your proposals, given the discussion that you've heard today. I would ask that you consider 2 things. One, if the revision will get you a 2/3 vote. If it will not, if that's worth doing at this late point in the process. 2, there are a number of you, if not most of you, who have expressed a real interest in trying to get to a vote today. So if any of these proposals that might be considered for revision become problematic to the question of whether or not we can proceed forward with a vote, I'd ask those of you who may have those concerns to reach out to those authors and let them know that, so that's part of their consideration when they make a decision whether or not to proceed with a change to a proposal. Do I have, is that clear to everyone?
If I may, just one point of clarification. I would also suggest that if there are task force members who are unready today to vote on something, whether it has been changed or not, we need to know that. So do not restrict that just to the ones that are being amended on the fly today. That's any of them. If somebody objects to votes being taken today, categorically, we need to know that. Thank you.
Thank you, Perry. That would be helpful. Just a note on voting. If we are able to proceed forward with a vote, we have a couple of considerations just to put out there. We've talked to Scott Woodall, may or may not be able to make it over, so we might see if we can actually get him here and present. Same with Randy Cleveland being on the phone. The other consideration, Peter D. offered a suggestion. He has authorized Lynn Smith, and we've extended this to the other alternates, to show his vote as we go through the voting process. And then he'll follow that up formally with an electronic vote. But Peter thought it important that when we leave the room today, we know the finality of votes. So that's not a question left hanging as alternates weigh in with an electronic vote. So that's just out there for consideration as well. All right, we're going to give 15 minutes and check back in with you all and see where you're at. If you need more time at that point, let us know. But otherwise, let's come back in 15.
I'm glad to know that. It's yeah, but he's not.
Go ahead and get started. The purpose of this conversation will be to hear from task force members who would like to offer changes to their proposals. And what I'd ask is if you're going to suggest a change, if you please walk through the change with the task force so that folks can ask a question or get a clarifying answer. If there is an issue with such change, any change being proposed, impacting potentially on voting, please raise that issue during this part of the conversation. All right, with that, I think we are all assembled. All right, task force members, who would like to weigh in if they have any changes to any of their proposals and what those changes might be? Is there anyone who'd like to go first? Becky Corliss.
Knocked myself in the head with this. I think I'll leave this one for you.
Go ahead.
The first thing I'd like to do, because it's become clear to me that there's some confusion about this, is to again state that it's 12A, the alternative that I brought in this morning, that would be before the task force for a vote, not the old 12A. So if anybody has any confusion about that or doesn't have the applicable 12A in front of him, her, that I would like to
So
make sure
my
that I
understanding, you
correct
would
that.
have a vote on 12A alternate and
12A alternative,
Okay,
yes.
just those two.
Right. It was handed out as a single pager this morning, and it's not in your packets. Then, with permission, Matt and I have some conversations that we need to have about the standing provision. I'm not sure that we're entirely ready to proceed with that, so may I park that for a moment? Because we're not sure what amendments we're going to propose to that.
Okay. Okay. John Golden Dubois?
As to recommendation 39 regarding the water quality monitoring, I wanted to take Bruce Rao's suggestion and in paragraph 1, keep only the first sentence. So the remainder of that paragraph would just be stricken.
Say that again.
Number 39, paragraph 1, we're under description. In that paragraph, we would only keep the first sentence, so ending at the word facilities. The rest of the paragraph would be stricken.
Okay. Is that change clear to people? Any discussion? Okay.
I'm still confused, Christine, I
Yes.
apologize. So John, the description would be one sentence, yeah?
Correct.
And then you would cut down to monitoring requirement specifications?
Correct.
Okay, and the rationale remains the same, the rest of it remains the same. So you're deleting from after completing an analysis all the way through specified in the recommended new regulations?
Correct.
Got it, thank you.
Okay. Anyone else? Gwen Lacko.
Okay, proposal 42 on the full and public disclosure, just so it's explicit and not implicit. I don't know exactly where we would add this, so I'm just going to put it in the title, where it says recommendation, full and public disclosure of the chemicals used in oil and gas operations, comma, no trade secret protections.
So that's clarifying some of the discussion we had earlier on number
Recommendation 42.
42.
So in the title, after recommendation, it reads full and public disclosure of the chemicals used in oil and gas operations, comma, new language, no trade secret protections.
We are tracking these changes. We don't have a projector, but we're tracking the changes, so they're finalized. Okay. Anyone else? Okay. Becky and Matt, I think we might be back to you. Do you need a couple of minutes? Okay, do you want us to call a timeout? How long do you need?
2 minutes.
2 minutes. 2-minute timeout.
It's like a calorie bomb. Oh, yeah.
All right, we have Becky Corliss and Matt Sura back.
Okay, we are merely going to amend the descriptive information to comport it with the.
Which number, I'm sorry, Becky?
We are on 21B.
21B.
As amended and resubmitted this morning, where we took out the neighboring surface owner, the neighboring surface owner standing to request a hearing. So now it would just be, the description would read as follows. Change COGCC Rule 503B7 to give neighboring surface owners notice, period. Remove the threshold requirement for local governments to appeal a drilling or location permit. So the only change would be that we would take out that language, the ability to appeal, et cetera, and replace it with notice. As otherwise, the recommendation that is before you, actually, there's one other change, isn't there, Matt? Don't we want to add in local governments in, 6 rather than municipal becomes local.
Still keeping the 15-hour clip.
And as otherwise submitted to you this morning, it stands.
Becky, did you need to add paragraph 1 back?
Sure. The description?
Yeah.
Change COGCC Rule 503B7 to give neighboring surface owners notice, period. Remove the threshold requirement for local governments to appeal a drilling or location permit. Then sub 1 comes out.
You were asking if we're going to keep sub 1?
It just seems you were referring to adjacent.
Oh, you wanted to put 1
Neighbors.
back in again, Bruce, since we referred to it up in the description?
Yeah, I don't think it has any other effect other than telling you what you're talking about.
That's fine. Okay. Friendly amendment. So one would, the strikeout would come out and one would go back in. The strikeout, the salient strikeout is 4. And then we would put the word local into 6 in lieu of municipal. And this is 21B. If anybody is confused, which I could certainly understand, please say so, and maybe we could have this copied off again, or.
I'm saying so. Would you just cover those all one more time? Sorry.
That's what I was trying to clarify for everybody. So this is the one that.
Okay, so Becky, I'm going to cover it and see if, and you can correct me if I'm wrong.
Okay.
All right. So with 21B, the original paragraph 1 that was shown as stricken out this morning would remain, would no longer be stricken out. Paragraph 4 would continue to be stricken.
Yes.
And in paragraph 6, municipal would become local.
Yes.
Those are the only changes?
No, the description changes
Okay.
too, Sarah.
Okay, so can you go over that change?
Yeah. Do you have it in front of you, the one that we handed out this morning?
I have the original, I don't have the, but you didn't change the description from the original?
No, the description should be the same across both. The first sentence would be changed. It would now read, change COGCC Rule 503B7 to give neighboring surface owners notice, period. The rest of the first sentence would be stricken.
Notice.
Just give them notice.
Right, and not appeal. And not appeal. Well, it just makes this consistent. with what they want to do.
One in strike, the rest of the service.
One, sub-bullet 1 would be in. Since we've referred to neighboring surface owners, we have to define them.
And it gives landowners, not just.
But 4 is out.
Which is out.
Any discussion with these changes that Becky Corliss and Matt Sura are proposing? And everyone has them captured?
I apologize.
All right, any other changes to be suggested to proposals at this time? I have the question in the task force is, are people ready to weigh in on voting? Or do you need some time to caucus and talk about that? Bruce Rao?
So just so that I'm clear, I think we have today generated revisions to 12A, 39, 21B, and 42. Is that the total of the documents that were amended today?
That's what I have too.
Okay. And then we had amendments submitted Saturday, or this morning, or Saturday, that included 17 and 20 and 49.
Some of those were submitted on Friday.
Since, I would say since the last meeting, yes.
No.
Oh, that's true, that's revision.
Did you mention 39, Bruce?
I have 12A, 39, 21B, and 42 today, 17, 20, and 49 since sometime on Friday, when documents came out.
So do people feel like they're ready to weigh in on the potential of voting today, or do you want time to caucus? Bernie Busher.
Thank you, Christine. I'm ready to vote, first of all. Secondly, I'd like to impose on staff that as we vote, because it's going to take a couple hours to work through all of these, I think, that those items that have been amended, we get amended copies so that before we vote, we have an actual document in front of us, so we're all working on the same.
We can do that right now. I don't think it's going to take that long to vote. We're going to move much in the format that we've used previously.
Okay.
So I think it'll go fairly quickly.
Okay.
But
Just so long as we've got.
I agree. We'll get you copies so you know what the final proposals are.
Thank you.
We're doing that as we speak. Yes, Will Tour.
A question on the format of the voting. Will it be roll call voting? So we'll have a record of the votes?
So what we'll do, we have to record a roll call vote as a final product of the task force, but what we have are our red and green cards. We have our alternates authorized to use those cards, so everyone can hold up their card. I will call your name. As I call your name and recognize your vote, you'll put your card down. Doug will tally the votes by person, so it will go into the formal record, and then at the end, we'll announce if it moves forward as a recommendation to the governor, if that makes sense.
Question, if I may. As I understand it, the immediate question before us is whether or not we need a caucus period right now to determine whether or not we are going to be ready to vote in a few minutes. Is that the
That is
only-
correct.
Okay, thank you. Just more clarification.
And we have a couple of minutes because we're going to get you all copies on the final proposal, so your packet will be complete. Any other discussion on voting? All right, we did say this would require a unanimous vote. I would ask our co-chairs to call for a motion.
All those in favor of voting today on all of our recommendations?
Raise your hand.
Please raise your hand. Signify by raising your hand.
All right.
Okay, any opposed? Couldn't see all the way down the line. All right, Mr. Co-Chair, I believe the vote appears to be unanimous.
All right, we will get those copies to you as soon as we have them for your packets. We'll commence with voting, so just give us a couple of minutes. Thanks.
Is it appropriate to break for further discussions among task force members while we wait for those copies to show up?
Sure. Do as you wish.
Or go to the bathroom if you want to.
Yes, ma'am.
I'm embarrassed about cover, brag, protect, all this press release. Recommendations, we always. This one is so. About 5 months.
Oh. That's a good idea. May not be able to get up.
Competing press releases, who would be relevant, including water versus vital Colorado, 3,000 relevant business leaders. Say X, Y, Z.
How we doing?
Mr. Co-Chair, if I may just make one lighthearted comment before we vote and we all take off to our different places where we live around the state. As you all know, I've been collecting money for some time, for about 5 months. Any unexplained acronym was $1 fine. I got about a whopping total of $33. And I was kind of thinking, well, maybe we should pick names from a hat, and then Brad could walk home with 33 bucks in his pocket and, you know, fill up his car with gas or something. But then I thought, nah, let's not do that. And I was thinking, well, here's Keystone that's volunteered their time to help us out the last 5 months. And maybe they could dedicate this money to the program or person or whatever of your choice. So here you go, 33 bucks.
Oh my gosh.
Doug already wants
Give it to Doug. We are a 501c3 nonprofit. We accept all donations, and we will recognize the Oil and Gas Task Force in our annual report. Thank you. $33. Thank you, Gwen.
Madam Co-Chair, if I may make one additional request before we vote. Looking around at the task force members, there are a number of former politically important folks who have participated in lots of public processes, and it is common in those processes to have the phrase, "Before I cast my vote, I would like to explain the vote." I would like to ask that is not appropriate in this setting. We just are going to vote without having any more speeches. That was my request. Thank you.
And I thought I was the only recovering politician in this room.
Excellent. I think that was universally accepted as a good recommendation. If we are ready, does everyone have their red and green cards? So the process will be, we'll go through the proposals in the order that we discussed them today. I'll ask everyone to hold up their card with it representing their vote. I will go down our alpha list. As I say your name and recognize your vote, please put your card down. Doug is tallying the final votes for the record, and he will give us the vote total at the end of each vote. As we come to a proposal that is yours, if you would like the proposal withdrawn, just note that, and we will do so, note it for the record, and move on to the next one. Any questions before we get started? Okay, with that, let's begin with Proposal 17, Bernie Buscher's proposal. Please hold up your cards. Well, this is not hard to count. That is unanimous yes. Every task force member voted yes. We will note that for the record. (13B), Brad Hawley. Thank you. 13B has been withdrawn. 16B.
Withdrawn.
16B is withdrawn. Proposal 20, Pat Quinn. Please hold up your cards. Well, the math is easy. This is universally supported with a unanimous vote of the task force, so noted for the record. Number 14, Matt Sura. Please hold up your cards. I will call your name. As I recognize your card, please put it down. Sarah Berwinski is a yes. Bernie Buscher is a yes. Randy Cleveland is a no. Peter D. is a no. Jim Fitzgerald is a yes. Russ George is a no. John Golden Dubois is a yes. Brad Hawley is a no. Dan Kelly is a no. Becky Corliss is a no. Gwen Lackald is a yes. Steve Marino is a no. Perry Pierce is a no. Ken Pepler is a no. Pat Quinn is a no. Bruce Rao is a no. Jeff Robbins is a yes. Matt Sura is a yes. Will Tour is a yes. Elber Wedgeworth is a yes. Scott Woodall is a no. He's going to announce the count here in 1 second.
9 yeses.
That proposal will go into the minority report. Proposal number 7, Russ George, please hold up your cards. Sarah Berwinski is a no. Bernie Busher is a yes. Randy Cleveland, yes. Peter D., yes. Jim Fitzgerald, no. Russ George, yes. John Golden Dubois, no. Brad Holly, yes. Dan Kelly, yes. Becky Corliss, no. Gwen Lackelt, no. Steve Marino, yes. Perry Pierce, yes. Kent Pepler, yes. Pat Quinn, yes. Bruce Rao, yes. Jeff Robbins, no. Matt Sura, I forgot where Matt is, no. Will Torr, no. Elber Wedgeworth, yes. Scott Woodall, yes.
Yes.
That recommendation will go into the minority report. We'll move on to recommendation number 12, Becky Corliss. Please hold up your cards. Sarah Barwinski, yes. Bernie Busher, yes. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, yes. John Golden Dubois, yes. Brad Holly, no. Dan Kelly, no. Becky Corliss, yes. Quinn Lackelt, yes. Steve Marino, no. Perry Pierce, no. Kent Pepler, yes. Pat Quinn, no. Bruce Rao, yes. Jeff Robbins, yes. Matt Sura, yes. Will Torr, yes. Elber Wedgeworth, yes. Scott Woodall, no.
Yes.
That recommendation will go into the minority report. Recommendation 12, alternate A, from Becky Corliss. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, yes. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, yes. John Golden Dubois, yes. Brad Holly, no. Dan Kelly, no. Becky Corliss, yes. Gwen Lackelt, yes. Steve Marino, no. Perry Pierce, no. Kent Pepler, yes. Pat Quinn, no. Bruce Rao, no. Jeff Robbins, yes. Matt Sura, yes. Will Torr, yes. Elber Wedgeworth, yes. Scott Woodall, no.
Yes.
That recommendation will go into the minority report. We are now on 21B, Matt Sura and Becky Corliss. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, no. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, yes. John Golden Dubois, yes. Brad Holly, no. Dan Kelly, no. Becky Corliss, yes. Gwen Lackelt, yes. Steve Marino, no. Perry Pierce, no. Kent Pepler, no. Pat Quinn, no. Bruce Rao, yes. Jeff Robbins, yes. Matt Sura, yes. Will Torr, yes. Elber Wedgeworth, yes. Scott Woodall, no.
Yes.
That recommendation will go into the minority report.
Yes.
Recommendation 25, proposal 25, Brad Holly. Please hold up your cards. Sarah Bowenski, yes. Bernie Busher, yes. Randy Cleveland, yes. Peter D., yes. Jim Fitzgerald, no. Russ George, yes. John Golden Dubois, yes. Brad Holly, yes. Dan Kelly, yes. Becky Corliss, yes. Gwen Lackald, no. Steve Marino, yes. Perry Pierce, yes. Kent Pepler, yes. Pat Quinn, yes. Bruce Rao, yes. Jeff Robbins, no. Matt Sura, yes. Will Tour, yes. Elber Wedgeworth, yes. Scott Woodall, yes.
19 yes.
That proposal will be a part of the recommendations to the governor. Proposal 26, Matt Sura. 18? 18, yes.
I had 3 no's on that one.
18, that would be correct. He's a lawyer. Okay, number 26, this is Matt Sura's proposal. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, no. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, no. John Golden Dubois, yes. Brad Hawley, no. Dan Kelly, no. Becky Corliss, yes. Gwen Lackald, yes. Steve Marino, no. Perry Pierce, no. Kim Pepler, yes. Pat Quinn, no. Bruce Rao, no. Jeff Robbins, yes. Matt Sura, yes. Will Tour, yes. Elber Wedgeworth, yes. Scott Woodall, no.
Yes.
That recommendation will go into the minority report. Proposal 20, Scott Woodall and Russ George. Please hold up your cards.
Which one?
Oh, I'm sorry, 10. I was moving mentally ahead. 10. Thank you. Sarah Berwinski, no. Bernie Busher, yes. Randy Cleveland, yes. Peter D., yes. Jim Fitzgerald, no. Russ George, yes. John Golden Dubois, no. Brad Hawley, yes. Dan Kelly, yes. Rebecca Corliss, no. Gwen Lackald, no. Steve Marino, yes. Perry Pierce, yes. Kent Pepler, yes. Pat Quinn, yes. Bruce Rao, yes. Jeff Robbins, no. Matt Sura, no. Will Tour, no. Elber Wedgeworth, yes. Scott Woodall, yes.
Yes.
That proposal will go into the minority report. Proposal number 2, Jeff Robbins. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, yes. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, no. Russ George, no. John Golden Dubois, yes. Brad Hawley, no. Dan Kelly, no. Becky Corliss, yes. Gwen Lackald, yes. Steve Marino, no. Perry Pierce, no. Kim Pepler, no. Pat Quinn, yes. Bruce Rao, no. Jeff Robbins, yes. Matt Sura, yes. Will Tour, yes. Okay, we would like to correct, Jim Fitzgerald would like to correct his vote to a yes. Will Tour, I had Elber Wedgeworth, yes. Scott Woodall, no.
Yes.
That proposal will go into the minority report. We are on proposal 3, Jeff Robbins. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, no. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, no. John Golden Dubois, yes. Brad Hawley, no. Dan Kelly, no. Becky Corliss, no. Gwen Lackald, yes. Steve Marino, no. Perry Pierce, no. Kent Pepler, no. Pat Quinn, no. Bruce Rao, no. Jeff Robbins, yes. Matt Surrey, yes. Will Tour, yes. Elbert Wedgeworth, yes. Scott Woodall, no.
8 yes.
That proposal will go into the minority report. We are on proposal 4, Jeff Robbins. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, no. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, no. John Golden Dubois, yes. Brad Holly, no. Dan Kelly, no. Becky Corliss, no. Gwen Lackold, yes. Steve Marino, no. Perry Pierce, no. Kent Pepler, no. Pat Quinn, no. Bruce Rao, no. Jeff Robbins, yes. Matt Surrey, yes. Will Tour, yes. Elbert Wedgeworth, yes. Scott Woodall, no.
Eight yes.
That proposal will go into the minority report. Proposal number 9, Becky Corliss. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, yes. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, yes. John Golden Dubois, yes. Brad Holly, no. Dan Kelly, no. Becky Corliss, yes. Gwen Lackold, yes. Steve Marino, no. Perry Pierce, no. Kent Pepler, yes. Pat Quinn, yes. Bruce Rao, no. Jeff Robbins, yes. Matt Sura, yes. Will Tour, yes. Elbert Wedgeworth, yes. Scott Woodall, no.
Yes.
That proposal will go into the minority report. Proposal number 13, Brad Holly. Please hold up your cards. Sarah Berwinski, no. Bernie Busher, yes. Randy Cleveland, yes. Peter D., yes. Jim Fitzgerald, no. Russ George, yes. John Golden Dubois, no. Brad Holly, yes. Dan Kelly, yes. Becky Corliss, no. Gwen Lackold, no. Steve Marino, yes. Perry Pierce, yes. Kent Pepler, yes. Pat Quinn, yes. Bruce Rao, yes. Jeff Robbins, no. Matt Sura, no. Will Tour, no. Elbert Wedgeworth, yes. Scott Woodall, yes.
Yes.
That proposal will go into the minority report. Proposal number 18, Peter D. Do you want? I'm sorry, we had a different vote count, was on 13. You had 13 yes? Do other people have 13? Is that right?
I had 13.
Okay, we're fine. Just wanted to check. Okay, 18, Peter D., please raise your cards. Sarah Berwinski, no. Bernie Busher, yes. Randy Cleveland, yes. Peter D., yes. Jim Fitzgerald, no. Russ George, yes. John Golden Dubois, no. Brad Holly, yes. Dan Kelly, yes. Becky Corliss, no. Gwen Lackold, no. Steve Marino, no. Perry Pierce, yes. Kent Pepler, yes. Pat Quinn, no. Bruce Rao, yes. Jeff Robbins, no. Matt Sura, no. Will Tour, no. Elbert Wedgeworth, no. Scott Woodall, yes.
Yes.
That proposal will go into the minority report. Proposal number 19, Jeff Robbins. Please hold up your cards. Sarah Bawinski, yes. Bernie Busher, yes. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, no. John Golden Dubois, yes. Brad Holly, no. Dan Kelly, no. Becky Corliss, no. Gwen Lackold, yes. Steve Marino, no. Perry Pierce, no. Kent Pepler, yes. Pat Quinn, no. Bruce Rao, no. Jeff Robbins, yes. Matt Sura, yes. Will Tour, yes. Elber Wedgeworth, yes. Scott Woodall, no.
10 yes.
That proposal will go into the minority report. Proposal number 22, Scott Woodall. Please hold up your cards. Sarah Berwinski, no. Bernie Busher, yes. Randy Cleveland, yes. Peter D., yes. Jim Fitzgerald, no. Russ George, yes. John Golden Dubois, no. Brad Holly, yes. Dan Kelly, yes. Becky Corliss, no. Gwen Lackle, no. Steve Marino, yes. Perry Pierce, yes. Kent Pepler, yes. Pat Quinn, yes. Bruce Rao, no. Jeff Robbins, no. Matt Sura, no. Will Tour, no. Elber Wedgeworth, yes. Scott Woodall, yes.
$12 yes.
That proposal will go into the minority report. We are on to proposal 27. Elber Wedgeworth, Russ George, Perry Pierce, Becky Corliss. Please hold up your cards. That has unanimous support from the task force. That will go into the governor's recommendations. We are on proposal 31B, Bernie Busher and Elber Wedgeworth. Please hold up your cards. That has unanimous support of the task force. That will go forward to the governor. We are on 34B, Jim Fitzgerald. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, no. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, no. John Golden Dubois, yes. Brad Holly, no. Dan Kelly, no. Becky Corliss, no. Gwen Lackle, yes. Steve Marino, no. Perry Pierce, no. Kent Pepler, yes. Pat Quinn, no. Bruce Rao, no. Jeff Robbins, yes. Matt Sura, yes. Will Tour, yes. Elber Wedgeworth, yes. Scott Woodall, no.
$9 yes.
That proposal will go into the minority report. We are on proposals. Becky, am I to vote on 44 and 44A separately? Okay, 44. Becky Corliss. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, no. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, yes. John Golden Dubois, yes. Brad Holly, no. Dan Kelly, no. Becky Corliss, yes. Gwen Lackle, yes. Steve Marino, no. Perry Pierce, no. Kent Pepler, yes. Pat Quinn, no. Bruce Rao, yes. Jeff Robbins, yes. Matt Sura, yes. Will Tour, yes. Elber Wedgeworth, yes. Scott Woodall, no.
$12 yes.
That proposal will go into the minority report. 44A, Becky Corliss. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, no. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, yes. John Golden Dubois, yes. Brad Holly, no. Dan Kelly, no. Becky Corliss, yes. Gwen Lackle, yes. Steve Marino, no. Perry Pierce, no. Kent Pepler, yes. Pat Quinn, no. Bruce Rao, yes. Jeff Robbins, yes. Matt Sura, yes. Will Tour, yes. Elber Wedgeworth, yes. Scott Woodall, no.
$12 yes.
That proposal will go into the minority report. We are on to Proposal 42, Gwen Lackolt. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, no. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, yes. John Golden Dubois, yes. Brad Holly, no. Dan Kelly, no. Becky Corliss, yes. Gwen Lackolt, yes. Steve Marino, no. Harry Pierce, no. Kent Pepler, no. Pat Quinn, yes. Bruce Rao, no. Jeff Robbins, yes. Matt Sura, yes. Will Tour, yes. Elber Wedgeworth, yes. Scott Woodall, no.
$11 yes.
That proposal will go into the minority report. Proposal 43, John Golden Dubois. Please hold up your cards. Sarah Bowenski, yes. Bernie Busher, yes. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, yes. John Golden Dubois, yes. Brad Holly, no. Dan Kelly, no. Becky Corliss, yes. Gwen Lackolt, yes. Steve Marino, no. Harry Pierce, no. Kent Pepler, no. Pat Quinn, yes. Bruce Rao, no. Jeff Robbins, yes. Matt Sura, yes. Will Tour, yes. Albert Wedgeworth, yes. Scott Woodall, no.
$12 yes.
That proposal will go into the minority report. Proposal 41, Harry Pierce. Please hold up your cards. That proposal will go forward to the governor with unanimous support of the task force. Proposal 35, Jeff Robbins. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, yes. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, no. John Golden Dubois, yes. Brad Holly, no. Dan Kelly, no. Becky Corliss, yes. Gwen Lackolt, yes. Steve Marino, no. Perry Pierce, no. Kent Pepler, yes. Pat Quinn, no. Bruce Rao, no. Jeff Robbins, yes. Matt Sura, yes. Will Tour, yes. Elber Wedgeworth, yes. Scott Woodall, no.
$11 yes.
That proposal will go into the minority report. Proposal 36, John Golden Dubois. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, no. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, yes. John Golden Dubois, yes. Brett Holly, no. Dan Kelly, no. Becky Corliss, yes. Gwen Lackolt, yes. Steve Marino, no. Perry Pierce, no. Kent Pepler, no. Pat Quinn, no. Bruce Rao, no. Jeff Robbins, yes. Matt Sura, no. Or yes, I'm sorry. Will Tour, yes. Sorry, Matt. Matt Sura was a yes. Will Tour is a yes. Elber Wedgeworth is a yes. Scott Woodall is a no.
10 yes.
That proposal will go into the minority report. We're on to Proposal 37, Russ George. Please hold up your cards. That proposal will go, Jeff Robbins thinks. That proposal will go forward to the governor with unanimous support of the task force.
Can I pause for a second for a computer issue? Thank you.
Thank you. You ready? We're on proposal 49, Elber Wedgeworth and Bernie Busher.
No, we need 39. It's listed, we're going by order of the chart, so 39 is listed.
It'll be next. Yes, 49 and then 39. 49. Proposal 49, Elber Wedgeworth, Bernie Busher. Please hold up your cards. Okay, I will note that Randy Cleveland is a no vote. Everyone else is a yes vote on the task force. And Kent?
Are you sure you didn't?
He was a yes.
She wants to read them.
He was a
Yeah,
yes.
I think she wants to read them. We'll give it to her.
Lisa, Randy, you're comfortable. Okay. That proposal will go forward to the governor. Now we're on proposal 39, John Golden Dubois. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, yes. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, no. John Golden Dubois, yes. Brad Hawley, no. Dan Kelly, no. Becky Corliss, yes. Gwen Lackold, yes. Steve Marino, no. Perry Pierce, no. Kent Pepler, yes. Pat Quinn, no. Bruce Rao, yes. Jeff Robbins, yes. Matt Sura, yes. Will Tour, yes. Elber Wedgeworth, yes. Scott Woodall, no.
$12 yes.
That proposal will go into the minority report. We're on proposal 52B, Becky Corliss. Please hold up your cards. That proposal has unanimous support of the task force and will go forward to the governor. We are on proposal 53, Russ George. Sarah Berwinski, no. Bernie Busher, no. Randy Cleveland, yes. Peter D., yes. Jim Fitzgerald, no. Russ George, yes. John Golden Dubois, no. Brad Hawley, yes. Dan Kelly, no. Becky Corliss, no. Gwen Lackold, no. Steve Marino, yes. Perry Pierce, yes. Kent Pepler, yes. Pat Quinn, no. Bruce Rao, yes. Jeff Robbins, no. Matt Sura, no. Will Tour, no. Elber Wedgeworth, yes. Scott Woodall, yes.
$10 yes.
That proposal will go into the minority report. Our last proposal, proposal 55B, Bernie Busher and Gwen Lackold. Please hold up your cards. Sarah Berwinski, yes. Bernie Busher, yes. Randy Cleveland, no. Peter D., no. Jim Fitzgerald, yes. Russ George, yes. John Golden Dubois, yes. Brad Hawley, no. Dan Kelly, no. Becky Corliss, yes. Gwen Lackold, yes. Steve Marino, no. Perry Pierce, no. Kent Pepler, yes. Pat Quinn, yes. Bruce Rao, no. Jeff Robbins, yes. Matt Sura, yes. Will Tour, yes. Elber Wedgeworth, yes. Scott Woodall, no.
$13 yes.
That proposal will go into the minority report. We'll go through those going forward with 2/3 support to the governor. As a recommendation, all other proposals will be reflected in the minority report. Both set of recommendations will comprise the final report to the governor. We will attach as appendices all of the minutes and process materials from this from the task force work since September. But Sarah, if you could read off those that will be going forward to the governor with 2/3 support.
Okay, so just to review, proposal number 17, Bernie Busher will go forward. Proposal number 20, Pat Quinn will go forward as a recommendation. Proposal number 25, Brad Hawley will go forward as a recommendation. Proposal number 27, Wedgeworth, George, Pearson, Corliss will go forward. As a recommendation, Proposal 31B, Elbert Wedgeworth and Bernie Busher will go forward. Proposal number 41, Harry Pierce Clearinghouse will go forward. Number 37, Russell George will go forward. Number 49, Elbert Wedgeworth and Bernie Busher will go forward. And number 52B, Rebecca Corliss will go forward as recommendations. And all of those had really strong support.
Thank you all. That concludes the business of the Oil and Gas Task Force of the Governors. Appreciate your time.